guys, good morning. Um, I just don't feel like being camera ready this morning, so I'm not. Okay, we are still outside the presence of the jury on the Phil Spector trial. Um, Yesterday, uh, we ended with another outside the presence of the jury. It was somebody from the lab. They were talking about that stupid fingernail, acrylic fingernail. I don't know why it keeps coming up. I'm still confused on what the heck that is even about. Like they saw something white. Hey, Carla. I don't know. I'm so confused about this stupid. First, they said it was a tooth. Then they said it was a fingernail. I, I don't know. They called it. They keep asking about bullet wipe. The chick from the lab said, um, she doesn't use the term bullet wipe. I don't know. I like the trial part of the trial. This thing about the fingernails aggravating me. But like I always say, you have to take the boring with the interesting, the good with the bad, because that's what makes a trial. Hey Nancy. So you have to take everything because it's remember the rule of completeness in a trial, you have to listen to everything. And for some reason, this is an issue, so we have to listen to it. Carla, you missed yesterday was fireworks. Yesterday was the best day yet. I was even screaming. Hey Rodney. I, I was going, whoa! Is this what's his name? Cutler? Is that his name? The defense attorney? Oh my God. He was pointing his finger at the witness and yelling. And Judge Fiddler, is it Fiddler? He was like, whoa, wait a minute. You will not yell at a witness in my courtroom. I mean, he was not having it. It was so good. It was good. And they were talking over each other. And the witness, who I don't know if she's, no, it was actual trial. I don't know if she's airheaded or I think in a way, like she never wanted to testify. Because one of the first things she said was, I want to make it known I was subpoenaed. Something to that effect. Um, and then when she started her testimony, I was like, is this a a witness for the prosecution? Because she's acting like this trip to his house was like one of the best nights of her life because she was talking about how neat the house was. It was like a castle, and he had a popcorn machine in his house and all these cool things about the house. And she was smiling and kind of giggling a little bit. And I was like, wait a minute, what is happening? And then as she got to tell more of her story and her experiences, she was, like started to get upset and started to cry. And I was like, okay, well now I see. Now we're getting into the meat of the story. But like she never went to the police or anything. Like she never wanted him to get into trouble. She just thought that he had a drinking problem and he needed help. She never wanted to be on the witness stand. And the color like attacked her. It was which he shouldn't have done because she wasn't trying to do anything bad to Phil. Like he should have been more sympathetic. It was just outrageous. Absolutely outrageous. Unbelievable. I've never seen an attorney act that way in court. He's talking over the judge. There's objections. The judge, he's not waiting for the judge to rule. He's talking over the judge. The judge will go to say something. He's talking right over the judge. I mean, he was so out of line. I don't know why the judge didn't threaten him with contempt. I've never seen such. And then at one point, he threw his arms in the air and like did a whole 360 circle. I'm like, who are you doing that for, dude? What is your deal? I've never seen an attorney act that way in court before. It was unbelievable. I was just like, whoa, dude, what are you even doing? And then, of course, because he's pro hoc vice, which means he's licensed to practice in a different state, and he's there practicing because an attorney from that state asked for permission for him to be on that case. So he's from New York. So he throws out the, oh, I didn't know, Your Honor, I'm from New York thing, which, I mean, I'm sure that there's little differences from state to state, but generally, the rules of evidence and all that, and how you refresh your memory and how you impeach people, all that is the same. Hey, Terry, all that is the same from state to state. There's little differences, but I don't think there are huge differences. So I don't think he can just pull the state card out. So he's just ridiculous. So I don't want this outside the presence of the jury stuff. I'm ready to get it. I want to see him cross-examine every witness because I like the drama. I'll admit I like the drama. Okay, so I don't know who is. It just says outside the presence of the jury. It doesn't say who. The judge and counsel discuss exhibits outside the presence of the jury. It doesn't say there's a witness. So let's see what we got going on. Hey, Jilly Bean. Hey, Rodney. Did I say good morning to everybody? Hey, Nancy, Carla, Judy, Rodney. Hey, everybody. Terry. Hi, guys. Thanks for being here early on a Saturday morning. You guys rock. But yeah, if you missed yesterday, definitely go back and watch it because it was the best day yet. StreamYard, don't start your chiz already. Come on.
No. Okay. Just as a recap, I know it's been a while since we've all talked about these things, and the recap of the people's position. I'll state the following. The discovery cutoff date in this case was February 10th, 2007, with a few exceptions, things that are learned after that date. Obviously, immediate discovery is required under 1054. But anything that's intended to be used by either party, if it's known by that date, should have been turned over by February 6th.
Dang it. Stupid StreamYard. Already cutting off my audio.
On March 11th, 2007, well into this trial, or well into the discovery date, we received for the first time a report from a woman, or a reporter, of a statement by a woman named Jennifer Hayes. That report had been in the defense possession since March of 2006. On March 24th, 2007, we received reports of interviews and statements by John Behrens. The defense had been in possession of those statements for some 3 years. On April 16th, 2007, we were first notified of a lost box of discovery that the defense claimed to have in their possession, which contained, ultimately, we found out, some 16 reports. Those reports were dated from February of 2004 to April of 2007. 2 reports at least of statements by Pumpkin Pie, 3 reports at least of statements by Jennifer Hayes, a statement by Heather Wimet, we had heretofore never heard of, a statement by David Shapiro, although we were aware of the existence of David Shapiro, we were unaware of this particular statement. And then we received some partial pages that appeared to be parsed out. Either we didn't have the beginnings of them or we didn't have the ends of them. And there were references in all of that discovery in these 16 reports to letters and photographs that were referred to by various and sundry people. Finally, on April 7th, 2007, we received information that there existed a voicemail from one John Behrens. And John Behrens is referred to in some of the reports in the lost box as well. We immediately asked for this voicemail to be turned over. Heretofore, we have yet to receive that. We have received some information of I think it's a transcript, what can best be described as a transcript of this voicemail. Regarding the lost box, reports from, and what's so disconcerting, I guess, about this lost box is that it only appears to be lost from us. The defense does not appear to have lost it at all. We're all pretty savvy at circumstantial evidence, and I would simply ask the court to note the following. The reports date from 2004 to 2007, as I just indicated. Wherever that box was lost, it appears that the defense has systematically been able to find it anytime they want to. Between 2004 and 2007, when someone finally came to their senses and said, hey, you know what, we probably ought to turn this over to the people. Items from the lost box were taken out. There are fax stamps on the items, on some of the items. It appears that those items were faxed between and among defense counsel. At least one on April 7th, at least another on April 9th, 2006. Then those items were put back in this lost box because they forgot when they put it back in the box that it had a fax stamp on it. Then the box was eventually turned over and claimed, hey, you know what, Mr. Jackson, Mr. Dixon, we didn't realize that this box was around. Shame on us. Here's the stuff that was in it. The problem with that is that, for instance, the Jennifer Hayes statements have fax copies or fax stamps on them from Ms. Kenny Bodden's fax machine. And those date back to 2006. So the lost box wasn't really lost. And the items in it were taken out and put back, reviewed, faxed among themselves, and ultimately ended up in our possession well beyond the discovery deadline. Additionally, the photographs that, and this goes back to some of the photographs that the court has now seen. I objected to several of these photographs in the defense opening statement, and so we had an opportunity to fully litigate this issue. The photographs that Dr. Harold referred to as she believed they were around 30, those are actually the 55 photographs from Dr. Lee that we received, I believe, on Friday, April 27th, which was a week ago last Friday, 2007. The discovery statutes are very clear, notwithstanding counsel's very interesting interpretation of 1054 and his discovery obligations. I think Mr. Plord cited that his discovery obligations, I've never heard a more stretching interpretation of a Supreme Court opinion, that his discovery obligations don't actually begin until we've completed all of our discovery obligations. Which, in point of fact, Your Honor, I don't want to beat this dead horse because I believe it does redound with ridiculousness. Because my discovery obligations are ongoing, and if someone walks through that door right now and says, Mr. Jackson, I've got information to tell you, for instance, I don't know, somebody like Gregory Diamond, I would have an obligation to present that to the defense, which I've consummately adhered to, and Mr. Dixon has consummately adhered to. Anytime someone comes up with any discovery, we have an obligation to keep going. So taking that logic to its extreme, Mr. Plord's logic to its extreme, there would de facto be no discovery obligation on the part of the defense. they wouldn't have to turn over anything ever, because our discovery obligation never ends. That having been said, these systematic discovery violations by the defense appear at this point not to be something that was just overlooked, or things that were overlooked, or things that slipped between the cracks. These appear to be things that were specifically designed to advantage them and disadvantage us. Mr. Dixon and myself can only be spread so thin to interview witnesses or go forward with investigations when we get reports from, say, Jennifer Hayes, or Pumpkin Pie that we've never seen, or John Behrens that we've never seen, or amazingly enough, from Henry Lee, 55 new photographs that our experts now don't have time to look at, that our experts now don't have time to analyze. And I would, specifically with reference to Henry Lee's 55 photographs, draw the court's attention to the following. In his notes, Henry Lee refers to several photographs, and I don't have his notes in front of me, but I believe I'm safe in saying he refers to 3 photographs, or 3 items that in his notes indicate the word photo underneath them, possibly 4. In a letter to Leslie Abramson, Dr. Lee refers to his crime scene investigation and the time that he was actually at the crime scene, and he indicates to Leslie Abramson, I've attached 3 photographs, the 3 photographs to Miss Abramson. There are no timestamps on any of the photographs. We didn't receive them until April 27th, although we've been asking for any physical items or any items of photographic evidence that Dr. Lee may or may not have taken since at least 2005. We received them late, and when we received them, some appear to be in odd format. In other words, Judge, when we look at them and we pull them up on a DVD, which is how we received them, some of those appear to have a file name that says scan, which is indicative of, to me, of, I mean, I happen to do a little photography in my spare time, which isn't much anymore these days, and it's all your fault, Judge.
I'm happy to do it.
When I used to take photographs, I would take a photograph with a 35 millimeter SLR, and I would end up getting those negatives printed, and then I would have to scan those negatives into electronic format. And depending on the program that's used, normally it'll have the tagline scan. So it tells me that there are 35 millimeter photographs out there. Of those 55, I don't know, 18, 20, 25 maybe scanned photographs or scanned files. The others have a very specific electronic file stamp. And if you take digital photographs, you would know that that little card reader that comes out of your digital SLR camera, once it's placed into a receptacle and uploaded onto a computer, is given a file stamp number or file stamp name. And it's usually a series of letters followed by a series of numbers in chronological order. Well, the other half of those photos have those type of file stamps. Thus, we have requested, Mr. Ocampo and myself have requested numerous times that we get the negatives from any 35 millimeter photos that were taken, because the photos that we got are in some cases very, very poor quality, and the electronic file format in its original format, so that we can find out if, in fact, these photographs were all taken at the same time or at later times, because as the court may know, Dr. Lee has had access to the castle and the areas surrounding the castle since day 1, since day 2. And all of a sudden we find out, oops, it appears that Dr. Lee isn't going to have the negatives either. Those negatives were given off to another lawyer at another time, and oh my goodness, I can't seem to find those negatives. At least that's the last information I have, unless Mr. Ford has new information that I'm not aware of. So it appears that one thing after another, after another, after another seems to be going wrong with the defense. And the prosecution is left holding the bag with brand new evidence that we've never heard of, brand new witnesses we've never heard of, brand new photos we've never seen, file stamps and photos that seem to be odd in their compilation, and we can't investigate that fully. We've never received the raw notes or the original notes from Dr. Lee. We've now asked for the raw notes from some of the investigators that have investigated or taken these statements from these 16 reports that appear in this lockbox. I've been told this as late as this morning that Mr. Plourde doesn't believe that I'm entitled to those raw notes, or at least if I am, they're going to be heavily redacted, notwithstanding the fact that we have an obligation to go out and investigate and vet this information. Then comes Dr. Lee's appearance on court TV. At the back end of all of this, I give my opening statement based in no small part on the investigation of the Los Angeles County Sheriff's Department, based on the strategies and decisions that Mr. Dixon and myself have determined best fit the prosecution of this case, and based in no small part on representations by the defense as to what their case may or may not include, and what their experts may or may not say, what their experts have indicated in reports. Although we've never been given access to interview any of these experts, I was given certain reports. I finished with my opening, and later that afternoon, I see Dr. Henry Lee plastered all over court TV talking about certain conclusions and opinions and analysis that he has that I have never heard of. Not in his notes, not in his books, not in his reports, not in oral statements that were given over to me, nothing. I've never heard this information. This 72 inches that Dr. Lee so prominently was willing to talk about on court TV. The next morning, Ms. Linda Kinney-Bodden stands up to give her opening statement, and lo and behold, Ms. Linda Kinney-Bodden echoes Dr. Lee's remarks about this 72 inches that the blood spatter travels. And Ms. Bodden took me to task, if you will, by saying whoever gave me my information was wrong, and by implication stupid, and by implication incompetent. I can tell the court, you're an experienced trial lawyer yourself. If I had known that Dr. Lee was going to come to this opinion or testify to these conclusions or analyses, I probably would have taken that into consideration in my opening statement. Now that cow is out of the barn. Notwithstanding, that is yet again a Dr. Lee discovery violation. If in fact he had that opinion, if he had that conclusion, if he had come to that analysis, or if he had come to his conclusions by way of analysis, I was entitled to that. If he intends to take a stand and say that in front of this jury, I was entitled to that well before he decided to plaster that all over court TV after I had given my opening statement. And something tells me that when he talked to his publicist, he was pretty sad about when he was going to make his statement. And he knew that when my butt was in the chair, I couldn't get back up and take him to task for that statement. I go to all this as an indication, Your Honor, that I don't take my discovery obligations lightly. The reciprocal discovery rules exist for a reason. We have been prejudiced by the fact that the defense doesn't appear to give a hoot about their discovery obligations. We don't have time to interview these witnesses that we would have interviewed. Certainly, we don't have time to do it as thoroughly as we would have done it previously. My opening statement is my opening statement. It is what it is. And look, like they say in the military, we'll adjust and figure out what our next point of attack is with regard to Dr. Henry Lee. However, I don't believe that any of these mistakes, when taken cumulatively, can be deemed to be mistakes. It appears that this is a systematic effort to people and then go back and say, hey, you know what, we had so many years. And I guarantee when Mr. Plourde or Ms. Kinney-Bodden or Mr. Brunon stands up to speak, eloquently as they will, I guarantee one or the other of them is going to say something about the other lawyers in this case, and we can't be held responsible. Well, I guess I would implore the court, we, the prosecution, can't be held responsible. Mr. Spector has chosen to change lawyers and to do this over and over and over. It is incumbent upon them to maintain their discovery obligations, their legal obligations, notwithstanding how many people get their fingers in the cookie jar. I'll submit.
Thank you. Defense?
Yeah, briefly, Your Honor, I won't repeat information that we set forth in our pleadings, but I wanted to go over just sort of item by item. There were certain reports that we turned over late. I'm not going to sit here and say that we should be excused for that. So I offer nothing more than just an explanation as to what we think happened. Essentially what was going on during this time period is we were producing a lot of scientific discovery, other discovery, and we were deciding whether to put some of these people on the witness list. If the court has had an opportunity to review a lot of these statements of Ms. Laughlin and these other people and look at the reports, basically it's a close call whether we'll call all of these witnesses, but apparently the decision was made to call or to put them on the list, which then necessitated the discovery obligation that we didn't meet. And we don't have an excuse for that. Basically, they were misplaced. Different people maybe didn't know who was going to be put on the list, and that's what triggers the discovery obligation. And we take responsibility for that as being a violation of discovery, in the sense that some of the witnesses known to anybody. I'm not sure how we found out about her. I believe we heard about her from Miss Laughlin, Pumpkin something, and she's named in that report or reports, and that led to her. She was a friend of Lana Clarkson, etc. Much of what she has to say is not all that significant, but we believe a little bit of what she has to say is. As to most of the witnesses, the people were not only aware of them, they interviewed them. We had no reason to, we weren't trying to gain a tactical advantage by not turning it over on time. We simply may not getting those to the people in a timely manner as required by the discovery statute. And again, I'm not saying that we should be excused for that, but we did it inadvertently, and we'll just leave it at that. Mr. Jackson goes through all the other discovery, and there's mention in these reports that, for example, in Mr. Barone, he says that in his report, this is a witness that they talked to. I believe Mr. Barone was spoken to many times. He says, when we interview him, hey, I have a tape of Lana Clarkson that she left on my voicemail in the weeks prior to her death. We need to get a copy of that. Mr. Rosen tells Mr. Dixon about that, about the first week of April. We finally get that actually in our possession about the third week of April. We immediately sent it out to get it transcribed. We actually get the tape, back to listen to it and look at the transcript on the 27th, the day they have it in their motion. And we offer them a transcript. We say, if you want the recording itself, after listening to it, we said, we don't think we're going to use it, but we give them a transcript of it, and we tell them, if you want the tape, and this is a tape that they're complaining about that we got our copy of on the 27th, and they've never asked for the actual recording because we advised them that we didn't think there was much to this as far as us using it or not. In any event, we're not even obligated to give that to you because we didn't get it actually to evaluate it till the 27th of April, the day they filed their motion, and we decided after listening to it, there's nothing to it. They have a transcript of it, and we don't have an obligation to provide it anyway unless we decide to use it, and we haven't done that. And the same is true of the photographs. People give us stuff all the time. We've got other tapes from other people that we're not turning over because we're not going to use it. That doesn't mean we have to give them everything. It's not exactly 100% equivocal. In other words, they give us all tapes of everything, no matter what, but we give stuff that we have to use or that we decide to use. And that's essentially the way the discovery law is. And the same is true of the photographs for Dr. Lee. We got those, I believe, the 12th of April. We actually got that. There were some fax copies, the ones that he referred to that were sent to Lester Abramson, that were not very usable, but that's all we had. But we didn't get the actual digital CD-ROM until the 12th. In fact, we brought it up with the court that week before the jury came back on the 16th. And Mr. Jackson said, look, we didn't get this. We want it. I said, hey, we just received it. We're going to make a copy. We gave it to him the very next day. We gave it to him within 24 hours of when we actually physically got it. Under the law, there's no specific requirement that we provide photographs that an expert takes. Now, if we decide to use them, then we have to provide them. Well, we didn't even get them until April 12th. And we gave them all of them on the 13th. They've had them for almost a month now. Now, the court mentioned the other day that there was some unpublished decisions that say you have to give these over, or at least the trial courts have been sustained in making an order like that. Well, there's been no order that we turn over the photographs until, well, we've already turned them over. There was no order. It was just generally you comply with the discovery laws, which we feel we were doing. When we get those photographs, we turn them over. Mr. Jackson mentions notes. Sunday, I get an email from him. We want your tapes and your notes of your witnesses. I wrote them back yesterday saying, I'm going to look into tapes. I don't know whether investigators have tapes or not. There have been 4 or 5 investigators working on this. I'm going to check for tapes of witnesses that we're going to call, check for investigators who have notes, go through those notes. If there's anything in there that's discoverable on the law, he's going to get them. If there's opinions or conclusions or editorial comments, we're not going to give you those. Those we feel are going to be work product. But as to the statements of witnesses, so be it. Then we get to the issue of the negatives and the original electronic file stamp. The court has said, notwithstanding what the discovery law says, Dr. Lee brings those with him. We've advised Dr. Lee to do that. We expect he will do that. Whatever he has, he will bring with him. Now we get to the issue of Dr. Lee's 72-inch or more statement, which is what Ms. Kenny indicated in her opening remarks. And to understand the genesis of that, that's not something specific to this case. That's just a general principle about the type of blood splatter that we're dealing with in this or any case like it, is that they made a statement, which was nowhere in Dr. Harold's reports, that blood spatter only goes a maximum of 3 feet, I believe her, at least according to Mr. Jackson, her testimony would be. Now, Lynn Harold doesn't say in any of her reports that blood spatter only goes 3 feet, any more than Dr. Lee says it can go 72 inches or more. Those are general principles that may or may not apply to this on the facts or circumstances case. And essentially, Dr. Harold, for example, she looked at all of these items. She says, I found blood spots on this garment, but she doesn't say where everybody was and how far away they might have been. She elaborated upon that in her grand jury testimony, but in her report, she doesn't say that. She just says, there's blood spatter on this garment, there's blood spatter on this garment. She doesn't compare one garment to the other in her reports. She simply says, in her grand jury testimony, I looked at this, I looked at that, it's probably within this range, but that's testimony as opposed to her reports or notes. And the same would be true of Dr. Lee. He, in his reports, details out where the blood spatters are, what they look like and different things like that. So it depends on the question that you ask when you have an expert who says, well, in general, how far does blood spatter go? Well, it depends on all these circumstances. Then they explain that. There's really no definitive rule that is generally applicable to every kind of blood spatter. It depends on various circumstances that apply to a particular case. And the comment in the people's motion regarding Dr. Lee in this experiment, there was no experiment done in this case relative to the facts and circumstances of this case. There was no recreation as to interoral gunshot wound blowback blood spatter, as that term was used by Mr. Jackson. He's talking about general experiments that are a wealth of knowledge that Dr. Lee has, and I'm sure Dr. Harold has some, regarding how they developed information and developed these general principles. Now, I don't know what Dr. Harold's experimental basis is or foundation is for her opinions. Dr. Lee, I'm sure, because he didn't do any experiment relative to this. If he did, it would be in his notes and they're timely along with his reports. He's talking about experiments that have been done years before, some of them not even by him, but that were just reported in the scientific literature. And Ms. Kenny, at the conclusion, as a result of Mr. Jackson's opening remarks, called up Dr. Lee and say, look, they said that this blood spatter can go a maximum of 3 feet. Dr. Lee says, no, 72 inches or more, depending upon the circumstances. In other words, that's the real disagreement. It's sort of a take away the facts of this case is a theoretical or analytical issue when it comes to blood spatter. There's a disagreement as to those 2 points. Now, why there is, I really don't know. But that's what Dr. Lee advised Ms. Kenny of, and that's what went into her opening statement. She did a memo regarding her conversation with Dr. Lee, and that statement, that's been provided to the people. It was provided about a few days later, and that's basically what the issue is. And it seems like they were arguing that we did some type of an experiment and then we hid that from them. We didn't do any experiment related to this case. Unless there's other more specific questions regarding the photographs or anything else other than that, or the court has any specific questions, Mr. Bruno would like to address the issue of prejudice.
Sure.
regarding-
Your Honor, obviously, this is a complex case. It has many, many lawyers on both sides. It has a lot of investigators, has a lot of reports. And there's not a streamlined and highly rigid hierarchy of authority and responsibility, et cetera. It just isn't on either side, I would say, but certainly not on this side. But Mr. Jackson is, in a sense, denigrating his own skill and the people in his office and the investigators that are available to them. Coming to this matter late, finding out that there was this issue, that there was some reports that had not promptly been turned over, but now have been turned over almost a month ago, given the passage of time and the intervening events. It just, I can understand why there would be a poor mouthing of the circumstance that he finds himself in or they find themselves in. But the fact of the matter is that they're talking about 3 or 4 witnesses that they have. I don't know how many investigators on staff, I would say at least 100. They certainly have access to investigators. Sheriff's Department has numerous investigators. And if what they need to do is go out and re-interview these witnesses, because most of the witnesses came from their sources, the only new one is Hayes, they can do that. Just think of what happened last week with Gregory Diamond. Through whatever mechanism they employed, they made a call, got 2 of the top homicide investigators in the city of Los Angeles Police Department to do a very thorough investigation. So the idea that they are somehow precluded from investigating or getting information that would be relevant to the statements that these people made on a somewhat peripheral issue. I mean, it's important. First state of mind is obviously important, but it's a narrow issue that can readily be investigated. They don't have to go to some remote spot to interview these people. They know how to contact them. They can get their investigators to talk to them. So the one thing in all of this is a particularized statement of how they've been hurt. Our position is that this was not purposeful. We have given over, like they've given over thousands of pages. Many of the pages they've given back to us, we've given to them in the first place. So, and we've given them hundreds, if not thousands, of additional items beyond that. So it's not as if we are sitting in some darkened room thinking, let's hide Pumpkin Pie or let's hide Jennifer Hayes, and then we'll surprise them with the fact that we are going to contend that Miss Clarkson was depressed. I mean, that's a well-known fact, and it, as I say, originated with their witnesses. But right now, if the court were to ask, how have you been prejudiced? What problem has this belated receipt of the reports caused you? They haven't said that. They haven't said we can't find them now, or they won't talk to us, or something that would be sequelae to that to report. And that's because there really isn't any prejudice. Kind of like a gotcha. And both sides are trying to seek the truth. I mean, what Mr. Jackson says is true. An effort to find the truth, and it facilitates the location and ascertainment of the truth to have the information in a timely manner. Well, this is not a 3-day trial, but we give it to them on the first day of trial. It's going to be a 3-month trial. They have plenty of time to investigate. They haven't been prejudiced. And the problem of imposing sanctions, they haven't really addressed the sanctions, but it detracts from the ascertainment of the truth, and it punishes a non-guilty party. Mr. Spector had nothing to do with turning these over or not turning them over. He relies on his lawyers to do what should be done, and sometimes the lawyers drop the ball. And we're not blaming anybody, our predecessors, our current team. I mean, just stuff happens, that. So I would think that the initial inquiry was there a violation? 2, what was the nature of the violation? Was it purposeful or inadvertent? And then 3, what prejudice did it cause? And then 4, how can I remedy that prejudice? That should be like a useful trick in determining what the facts are and what should be done.
When was Dr. Lee's materials, his report, if there is a report, when was it turned over to the prosecution?
I believe I set that forth in my motion.
I know, but I have lots of things right now. I'm asking you before I have to refer
I
to the
believe
motion.
it was timely in sometime in February. See, one of the things that was happening, we were everybody was getting all the scientific information, the reports actually getting done, turned over, the notes, all of those were turned over in February, roughly 30 days before trial, maybe a day or two on the other side of it. But I could get specific here. Yeah.
I don't think they're complaining about that.
I don't know. I'm trying to sort of weigh everything because I'm considering how long Dr. Lee's been on this case.
February 14.
We got his report and almost every other expert's report. It was amazing. I couldn't believe that the defense could manipulate the U.S. Postal Service this well, literally on the 30th day before the discovery cutoff date.
And sometimes we were getting emailed reports to them that were unsigned, and later we would get them signed versions, basically, when we got the signed versions in the mail.
Correct. So it was somewhere around Dr. Bodden, Dr. Spitz, Dr. Lee, Dr. DeMaio, Souvron. The list goes on and on. There's 13, I think, experts that we ended up getting reports from, all of them within about a 1 or 2 day period on the 30th day before the cutoff, the discovery cutoff period was, which was February 16th or 19th, something like that.
And there were a number of experts that we had look at things that we didn't give reports to because we made decisions right about that time period that we weren't calling them. And that's what we were doing. We're trying to decide, okay, who we calling, who we not. And the same was going on with the other lay witnesses. We wanted to first see what their witness list had on it. We got their witness list on February 16th, almost 30 days before trial. At the same time, our witness list was done. For example, Mr. Barone, he was a witness that talked to them. They gave Mr. Barone's statements to Dr. Pena as part of a package of material for him to review. Miss Laughlin, or Pumpkin, whatever her name is, they gave her statements to Dr. Pena, but they don't put either of those people on their witness list. Had they put those people on their witness list, we wouldn't have put them on our list, and we wouldn't have given them any discovery. So until we know on February 16th that they're not on their list, even though they interviewed them, they've given the statements to Dr. Pena to do his evaluation as to manner of death, we can't make a decision as to whether we put them on our list until right after that. So we were scrambling because we needed to know what went on, what didn't go on, and then we have to get the statements to back them up. And it was all going on at, sort of a crunch time. And again, we put their names on the list because we realized they weren't on their list. Even though we probably could have cross-examined Dr. Pena on those statements, but we had independent statements, and that's what occurred.
Is there any evidence that you presently have that's been requested that you're claiming you don't have an obligation to turn over?
Some they made a request this morning that we haven't. Well, yet Sunday they made a request for all notes regarding witness interviews. Some we think are discoverable, some we think are not. Obviously, any witness who's not on our witness list is not discoverable. Some of the notes, and I don't know the answer to this yet, I just made a call and left a message for our investigators, because we have one now that's been working on the case, but we've had historically about 4 investigators that work for other lawyers, and I haven't had a chance to even talk to them because the request was just made Sunday. They want tape recordings, which I don't know if they exist. I know that the investigator we have working, I talked with her this morning briefly. She says she has no tapes, so I have no reason to believe she does. She does. She's getting her notes together that comport to witnesses that have testified. As soon as I review them, to the extent relevant witness statements are in the notes, we'll give it to them. I haven't had a chance to even look at them or get them at this point. We have some photos that they asked for this morning regarding what some investigator took in 2003. They said, we heard that some investigator who's not on the witness list may have taken photos. I said, well, I don't think that they're necessarily discoverable. Our experts haven't seen them. Our experts haven't looked at them. Our experts haven't evaluated them. And why do we just have a general obligation to give photos from non-witnesses about anything? There are some things that Ms. Clarkson, her friends either showed us or gave us or told us about through witnesses that are not on the list, or some that are, that we're not going to use and we don't intend to use, and we don't think we have a general obligation to turn those over, at least from my reading of the discovery statute. I put that in my motion. I've told that to Mr. Jackson and Mr. Dixon. So to answer the court's question, they're contending outside of this discovery motion that there is additional things that we may have that they want. But for example, the recording of Miss Clarkson, if we were going to use that, we'd turn it over. We've offered to give it to them, even though we're not going to use it. They never asked for the actual recording. After we gave them the statement, my sense is they decided, well, we don't want to use it either. Who cares about it? But we're not trying to hide it. We're not trying to, but we have no obligation to provide it either. We've got no specific obligation. So unless they know of something specific, you know, our position is that we're in compliance as best we can right now with the discovery obligations, and the recent requests that were made just today and yesterday, we're working on.
What items, if any, is the prosecution requesting at this time that you believe you don't have?
Based on the information provided in the lost box, if you will, I've reviewed several of the witness statements, and the genesis for my request for possible tape recordings is how the witness statements are written. These reports are written almost in a bizarre he said, she said fashion. This one particular defense investigator writes the reports almost quoting lines the entire time, and it looks to me like nobody could reasonably do that without tape recordings. So based on that, I've asked for tape recordings and raw notes, the same type of tape recordings and raw notes that we traditionally give over behind witness interviews by the police in our case. I've asked for the same thing. That's what Mr. Ford was just talking about. He was saying that, or indicated this morning that Tawny Tyndall, I think, has indicated to him that she has no recordings, which I find incredibly confusing based on how her reports are written. 4 or 5 pages of very specific quotes and dialogue. But if that's her position, then that's her position. I'd like her to be, I'd like the request to be made of her. And if she has raw notes or recordings, I'd like those. I was also informed this morning by that there may have been a defense investigator who was taking photographs of the events that are at issue in the discovery hearing concerning Dr. Lee, the white item, if you will, Judge. I want those photographs. Ordinarily, they may not be discoverable, and Mr. Ford could ordinarily be right that if they don't intend to use them, if their experts haven't seen them, so be it. But we're in an odd situation with this evidentiary hearing, and I think the court is entitled to see, the people are entitled to see if there are additional photographs that could corroborate Sarah Kaplan, that could corroborate Gregory Diamond, that could corroborate Stan White. The court certainly would want to see those, and I understand that those do exist. A series of photographs do exist of those individuals being in the foyer area on February 4th, 2003. That was the reason for my request this morning, not for the trial as much as for the evidentiary hearing. May I have just a moment?
Certainly.
I can't think that Mr. Ocampo and myself cannot think off the top of my head of any other outstanding discovery issues that we've requested and haven't received at this juncture.
And just for the record, I personally delivered the CD-ROM of Dr. Lee's photographs the day after I received it on the 12th of April, this, before we did our final jury selection. Personally delivered on the 13th with the cover letter of Mr. Jackson. CD-ROM, I gave him a copy of what we got. And I did it within 24 hours. Now, granted, maybe we should have asked for him before. And in fact, we did ask for him before, but it took time for us to get him and so forth. But I don't think that they are discoverable under the discovery laws. Now, just like when we did our laboratory visit, which we had our experts take photographs, and those photos were timely provided. But then they asked for my photographs that I took when I was there, because Mr. Brunon, myself, Ms. Kenny, we were there. I was taking my own photographs, to document what we were doing. They asked for those. I gave them those just as soon as they asked. But I don't think they were legally discoverable. It just happened to be that, that I took additional photographs. But just because we give it to them voluntarily doesn't give them an entire. One was made Sunday by email, the tape recordings, which Ms. Tyndall indicates she didn't have any tapes. That's all I can tell her. I asked her, she said no. I believe her. I'll question her again to make sure. But that was made
Her
some.
statement was she doesn't have any tapes now, or she's never had any.
She did not tape record the interviews at all. In other words, not that she got rid of the tapes.
That's
No.
what I'm asking, okay.
Yeah, I should have made that more clear. I hope I made that clear, Mr. Jackson. She did not tape record those interviews. She took notes, she says, but she says her notes have a lot of her impressions about the witnesses, that the detailed research have. If the court has taken any time to look at these reports of Ms. Laughlin and the other ones, 90% or more, I think the debate is whether 90 or 95% or more is totally irrelevant background material. She puts everything in there. She's a former bank fraud investigator. That's just the way she writes her reports. What can I tell you? But the reality is very little of those reports is actually relevant witness statements regarding issues involved in this case. The fact that they, what they're doing with their life and all this colorful background or whatever stuff is really not admissible. And we're not, but we had to give the whole report because that's what was written. Now, she has notes that back up those reports, but those notes also contain her impressions of the witnesses, maybe demeanor, things that we would tend to ask her later. So what did this witness, what was the attitude of the witness in your opinion, different things. That has nothing to do with the witness statements themselves. So that's the part that we want to look at to see if we should redact any of that or not, because we think that does kind of fall into a privileged area. And I haven't gotten the notes yet from the investigator. She's going to be collecting them, and we're going to get those to the people as soon as we get that done. It's going to take us some time, and now we're in trial. The reports themselves have all the meat regarding their interviews and so forth. So I don't think there's anything substantial outstanding that we're not working on, that we're not getting to with reference to this.
The only thing I was going to address, and I don't want to beat a dead horse, I'll try to be as pointed as I can. With regard to the photographs, there is a concept in the law called constructive possession. I don't think the defense can lean on the idea, well, we didn't get these photographs from Dr. Lee, so goodness gracious, as soon as I got them, I gave them to Mr. Jackson. Well, that should fall on legal deaf ears. Who cares when he got them? He knew that Dr. Lee had them. I've been asking for these and asking and asking. I asked Dr. Lee, I looked him right in the eyes at the crime lab in February of 2006 and said, Doc, did you take any photos? And he said, yeah. I said, let me have them. He said, I don't have these. I've given them to the lawyers months and months ago, years ago. He said he gave them to some lawyer that he couldn't remember, whose name he couldn't remember, back in 2003, I think. It was after that Mr. Sortino, myself, Mr. Ocampo, and every other DA that's had his hands on this case in any way, shape, form, or fashion has been asking for these. So to say, hey, look, we just got them, we, meaning Mr. Plourde specifically, or Mr. Brunon specifically, that is not a legal argument. With regard to the experiments and or opinions and conclusions concerning Dr. Lee and the 72 inches that we just heard of on court TV, the fact of the matter is, if he relied on experiments, I don't care if he did the experiments in this case or if he did it and did it for a case 10 years ago. It doesn't matter. If he's relying on experiments, that's part of his opinion and conclusion. If our people do the same thing, we have to turn that over. And Mr. Plourde makes this grandiose statement, well, Dr. Harold's opinions and conclusions are not contained in her report. 667 of the grand jury transcript. The miss-like pattern does not travel far, and this jacket is probably 2 to 3 feet of the discharging weapon. That's what her statement is. That was timely turned over to the defense, and that's what I said in my opening. That's the way this works. They can't simply say there's generic information out there. If it was so generic, Miss Kinney Bodden, certainly with her experience, she is a science guru. Why would she have to call Dr. Lee the day I sit down after giving my opening and saying, oh my goodness, I never heard this before. You mean miss-like spatter patterns only go 3 feet? How far do they really go, Dr. Lee? They can't have it both ways. If it's a general scientific precept, then she would know it. She wouldn't have to call him. The matter is, I should not have heard the concepts of the reciprocal discovery statutes. That's the problem that we've had. Is it's not a single event, Judge. This has been systematic over and over and over. And for Mr. Brunon to stand up and look, he and I go way back as well. He knows how to try a case. Are you kidding? Look, how hard can this be? I think he used the word that I denigrated myself. Well, I probably do that daily, but it's not I did it with this regard. And then I poor mouthed about not getting my discovery. Well, that falls into the legal argument of get over it. Well, Mr. Jackson, so I violated the discovery statutes. Get over it. Well, we may or may not be able to get over it, Judge. I won't know what the actual prejudice is until we get going on this. And the fact of the matter is Greg Diamond, whom he uses in one of his examples, Greg Diamond comes forward. How many days have we spent vetting Greg Diamond? That's one person. Now we've got Jennifer Hayes and John Behrens and Pumpkin Pie Laughlin, and it goes on and on and on. I won't belabor the point. I think my point is clear. We are prejudiced by the fact that we can't do what we should have been able to do before we started trial. Mr. Dixon and myself, we have a date with this court every day. I can't be sending the hundreds and hundreds of investigators that I wish I had out in the field doing this investigation. It's ridiculous. This never should have happened. And Mr. Dixon, myself, the prosecution, the people of the state of California shouldn't suffer because of any incompetence, and a present company possibly excluded any incompetence or purposeful actions on the part of the defense.
Your Honor, could I keep my name something?
All right.
Just very briefly, and I won't be there. Your Honor, since I was the one, I'm very uncomfortable. When I stand, I'm uncomfortable addressing.
Stand or sit. I told counsel they don't have to stand when they address me. If you want to, that's fine.
I'm uncomfortable where I come from, where I stand, so it just makes me.
This is Southern California.
That's what I've heard, Your Honor. Thank you. Mr. Jackson gives me a lot of credit, and I really appreciate it, but a statement that blood spatter can only go out a maximum of 3 feet was first indicated in his opening. As a matter of fact, I was really surprised by that, and I thought that I had missed some literature that I had not seen in the past because I was aware that a lot of literature. I was aware of courses, and the Herald had recently, as Sarah, I was aware of talks courses, I was aware of pins, but I had never seen any report, and there's none, that says talking in general concept that blood spatter of this type can go maximum of 3 feet. So I immediately called our experts saying, this is the first time I'm hearing this from them, and it was the first time, because he didn't say what Lynn Herald said in grand jury. If he said that, that would have been fine. He said that this type of blood spatter can go a maximum of 3 feet. And so thinking that there may be something new that I even had missed, I called and found that absolutely not, that generally, and it's not an experiment with this case, and generally, depending on the circumstances, this type of blood spatter can go a certain amount of feet, and to just say that it's a maximum of 3 feet would be wrong. And that could be the kind of stuff that I would have questioned Lynn Herald on, and I intend to question her on a cross-examination, because it's general principles. But to say that in this case, that was an indication that it had come from an opinion of an expert that we had not heard before, that possibly I missed something that I had never seen before, and therefore it had to be addressed. But it was in general scientific principles, and quite frankly, it didn't even have to be in any report unless it's her conclusion. And I would venture to say that when she gets on the stand, she's not going to say a maximum of 3 feet at all for all this type of blood spatter. I think that was probably a mistake or a misspeak. But therefore, for me not to have to address that in response to something I first heard that is not in her reports and is different than her grand jury when she just gives her opinion about what it could be as opposed to what this type of general blood spatter can do would have been unfair to Mr. Spector.
Thank you. Certainly. Yes, go ahead.
Counsel is simply incorrect in asserting that the people are entitled to materials that any expert may have relied upon.
I'm about to address that. So I don't agree with that comment.
Well, it's not my comment, it's People v. Hines' comment.
I have Hines. I'm familiar with Hines. I said, if you don't have the site, you can find.
It's 20 Calab 4th, starts at page 1818. The part I was about to quote is at the end of page 1823.
It's a 1993 case.
Well, it certainly hasn't been disapproved.
No, I'm not saying that in any derogatory fashion. I'm just saying it's a 1993 case.
And Your Honor, when we wrote our papers, it was my impression that, and all I had to go on was Dr. Lee talking to Catherine Cryer, that I assumed that the experiment that he talked about doing, because his words were, we did experiments. We did experiments. And the blood spatter travels a certain distance. So that was the reason for including that in my, I'm well aware of generalized experiments in the world don't have to be turned over. But I was under the impression that Dr. Lee conducted an experiment in this case, and that I would be entitled to.
Had he done it, we would have had notes and reports regarding, but if we as the general scientific community, I don't even know if Dr. Lee, I haven't even asked him whether he's ever personally done it or been involved in experiments regarding this subject. I assume he had, because I've been to seminars 10, 15 years ago where Dr. Lee talks about blood spatter, and that's what these guys, it's an experimental based science. And so, but what, I'm sure it goes to experiments that he's aware of, as well as some that he may have even been involved in. But we're not going to give a report about every one of those. We don't think we're obligated to do that.
First of all, the defense is ordered to turn over to the prosecution any photographs that they may have that have not yet been turned over, if, one, they are part of any expert's report, specifically if the expert is going to testify to them, or two, if in any way an expert has relied on a photograph in forming an opinion, whether or not specifically set forth in the report, then you are ordered to obtain and turn over to the prosecution forthwith any such photographs. As to notes, if you have a witness and you have a report and there are original notes, they will be turned over, with the exception that if you are claiming a work product privilege or some other privilege, then you may redact them, but you will provide the originals to me to compare to any redacted version so that I can see that what's redacted is properly redacted and is not discoverable by the prosecution. All right?
That's what I offered to do with Mr. Jackson.
In any event, at this point, the request by the prosecution is that witnesses be excluded. I'm not willing to do it at this point. I don't see that kind of prejudice, number one. Number two, if you obtain a conviction in this matter, and I have excluded a necessary defense witness, except in extreme circumstances, you can pretty much count on that conviction being overturned. That's an extreme remedy. I am not saying that it doesn't exist. It does, because that's one of the remedies that is spoken of in the appropriate cases, but it is considered to be an extreme remedy. And I haven't yet heard anything that would mandate that. Well, I'll get to other possible remedies in a moment. Also, if Dr. Lee, as to this blood spatter evidence, if he conducted an experiment for the purpose of this case, then that is to be reduced to a report, and that report is to be made available to the prosecution. If in arriving at his opinion, which he conveyed to Ms. Kenny Bodden, then all he used was his general background knowledge, that doesn't have to be reduced to anything. That's just part of what he could be cross-examined upon. If he's used books and other things, of course, that'll come out in cross-examination. You can't get every text or every experiment an expert has used unless it's specifically, in my mind, used in this particular case. So if he did something to arrive at the comments he apparently made on national television, if that's in a written report, it's to be turned over. If it was an oral report, then it's either to be reduced to writing, or you are to report orally to the prosecution what he did in relation to this case. It depends on the specifics.
Your Honor, I'll represent to the court, as Kenny and I have talked about this, Dr. Lee would not have done anything in this case unless we knew about it. In other words,
then you don't have to worry.
Right.
I'm just telling you, if it exists, that's...
In the abundance of caution, I will ask Dr. Lee if he did something without telling us. But the other thing is, I would indicate that we provided the curriculum vitae of Dr. Lee, who has published hundreds of different articles on a number of different subjects, including blood spatter.
I understand
so they know about it. They know about it.
I'm just issuing a ruling.
Okay.
All right. Thank you. Now, I have read a majority, or at least one of the more serious concerns of the prosecution as set forth by them, were the additional reports from witnesses that they originally knew about Ms. Laughlin, there are one or two other witnesses. The reports, which have been filed under seal, and I have to be honest with you, I don't think they can stay under seal. Had they been turned over long ago when they should have been turned over, or if they should have been turned over, I'll get to that. They would have been part of the record, if you will. They do contain some of its opinion. Maybe the best thing, these are individuals who claim to be very close friends with Ms. Clarkson. As the old saying goes, with friends like that, who needs enemies?
Right.
A lot of it will never be admitted at trial. It's clear that it's irrelevant. It has to do with her lifestyle, and other than her any expression she may have made about depression or what she wanted to do with her life, which are relevant, and I assume they will be brought forth and will come out. Those are fine. Even though it may not be admissible, it's no different in my mind than if you have a hearing to suppress evidence and the defense says, please close the hearing, judge. You know, if you suppress this, the jury pool might know about it and we're forever prejudiced, and the case law is pretty clear. It's you deal with it. Of course, you deal with it in voir dire, which in this case isn't necessarily present. But the bottom line is, I think those reports are going to have to be made public. I just want to give everybody a heads up, and I'm sure it's going to be painful for the family. I will say there's nothing, when I say painful for the family, there's nothing in there that's of any, some amazing revelation. It's just, people, it's not pleasant. I mean, there's things about her personality and perhaps things that she did, which certainly I don't think the family's going to want to read, but that's not the test. It's not so prejudicial that it's going to impact the people's right to put on a fair case. So I'm just letting you know, although they were filed under seal, I intend in all likelihood to just file them as part of the motion. I think you filed one form of the motion that has all the reports in it, and that's the one that'll probably go in it. If not, I'll just add the under seal items into the motion. With that for a moment, suggesting that there's any basis for getting these, the majority of the reports in, as I previously indicated. So I don't know how much the people are prejudiced. Yes, it makes you do extra work. I agree. And by the way, these violations, whether they're negligent or whether they're deliberate, there's too many of them, this whole box of reports, to say, well, that's just the way it is. It's not just the way it is. The defense has the same obligation, whether they like it or not. I'm quite sure if the shoe was on the other foot and the prosecution was the one not turning over these documents, and they said, look, we didn't do it deliberately. We've got a box. We forgot to bait stamp them. We forgot to turn them over. You'd be making the motion and not the prosecution. That doesn't answer the question of what the appropriate remedy should be for what is clearly, as to certain items, a discovery violation, which has been conceded. Because there's so much that's not coming in these reports, I'm not sure how prejudiced the people have been, certainly not to the level of excluding witnesses, as to whether the court should consider, at the close of the trial, giving what has now become CalCrim 306, which appears to answer the criticism of former CalJIC instruction. I want to say it was 288, but I'm not sure. I could find it. It's not important. The former CalJIC instruction, because the CalJIC instruction allowed the jury to infer that counsel's misfeasance or malfeasance, as the case may be, could be attributed to the defendant, which was the fatal flaw in the instruction. The CalCrim instruction specifically states that it's not to be used in any way on guilt or innocence. Frankly, I think it can be better written. To be honest with you, I might, if I ever give it, and that depends on how all this case plays out. And frankly, I'm going to look at how the witnesses and whether I think the people have been in any way significantly prejudiced by any discovery violation. If I find they're not, then I'm not even going to, I'm not going to raise it. There's a separate issue with Dr. Lee. That has to be dealt with, and that is not this general discovery issue. This is the issue which we are attempting to resolve concerning the evidence at the house. And that's a different story, and I'll reach, when I find what the facts are in this case, in that matter, if I ever do, then I'll determine whether anything needs to be done about it. But right now, the only remedy I would consider would be the possibly giving that instruction, and I'm quite a ways away from even thinking about that, until I see how the case plays out. If I'm satisfied that the prosecution has had ample time to do appropriate investigation and they have not been prejudiced in any significant fashion, I probably would not give the instruction. So we have to wait and see.
On the redaction, go ahead.
Is there anything else that anybody, before I will get to anything else on that?
Just a brief comment. The 2.28 was
2.28. Thank you. Right, and that had a fatal flaw in it, and that flaw, at least they have attempted to remedy it. It has not yet, as far as I know, been tested in the appellate courts, or we haven't had an appellate decision.
Well, the good news, I understand that the 306 was actually authored by Justice
Corrigan.
Well, Justice Corrigan led the committee
Right.
that was formed by Chief Justice George. As I always say, why do I use CalCrim instead of CalJIC? That's why.
And she's now sitting on the Supreme Court.
When two members of the Supreme Court sort of put these instructions out, of course, it'll be subject to some of the instructions. I've found some flaws in some of them, but they asked for that. They asked for input, and we will see. But I can think of, if I ever get to that, probably a little better way to write it. But that's neither here nor
the
there.
other thing I was going to ask
All right.
again while I'm thinking of it, because
Yes.
at this point in life you have to do that, otherwise it goes away. Would you give us a heads up at some point before the end of the trial if you
Yes.
are leaning toward that?
Yes.
So we can go.
Yes.
Can I have just a quick?
Well, I think the appropriate place is when the trial's over and we're talking about instructions. If the prosecution requests, I'm not giving it on my own. If the prosecution requests that instruction, then we'll sit there and argue about whether there's been any significant impact. First of all, I'd have to be convinced of a significant detrimental impact on the people's case before I touch that instruction. Minor violations or things that were, given the length of this trial, that they were able to counter and it did not impact them. It doesn't excuse necessarily the violation, but the question is whether there should be a sanction. That's a whole different.
What I'm concerned about is that there's a factual vacuum. We've, both sides have simply filed motions making factual assertions, but there's been no real factual record made. And it probably would be appropriate if we get to that point, or if we're getting near that point, that some factual record be made.
If it becomes necessary, if I'm leaning towards the giving of instruction, I'll give you an opportunity to establish any facts you need to show that it hasn't taken place. But I think the best way for me to do that is listen to the evidence, listen to the witnesses, see how the people rebut certain evidence. And if I'm satisfied that nothing serious has happened, then we deal with it. That's okay.
Yes.
Certainly. Without getting into it, they just, what we've discussed is a portion in a report that is completely irrelevant to any proceedings, and there's absolutely no need. It is, I think, extremely embarrassing perhaps to certain individuals without any probative value whatsoever. I might consider redacting if it's in any of the reports that you filed. I might read, and I think it was. I think I remember reading it. And for the same reason, I'll make the necessary finding that the reporter seal what just took place at the bench. It's very trivial, but it is not anything that I think should be out in the public domain. And I think there is, even to a decedent and that decedent's family, they do have some rights of privacy. That is the overriding interest that would support the sealing of the record. And that right would be substantially prejudiced if the record was not sealed. And it's as tailored as I could make it. It's very, very narrow. It goes to one minor or one small detail. And based upon that and prior orders that the court has made, that portion of what we did at the bench will be sealed. And if necessary, I'll redact any of the reports that were filed as part of the motion and then make the rest of them public.
Yeah, the other thing is that in a number of the reports, we asked the witnesses to give us names and addresses and phone numbers.
Yes, phone numbers, anything that would invade somebody's privacy can be redacted.
Very good.
You know, every individual has a right not to be contacted just because they happen to be a witness in a case or have some pertinent piece of information. They don't need their phone number out there. They don't need to be contacted. And all these little bits of information can also lead to identity theft in this day and age, which is a sad fact. And for all those reasons, those matters can be redacted. There is, I think that takes care of the discovery issues that I'm aware
It
of.
does, Your Honor. Thank you for your time.
Okay.
We filed one issue concerning a witness. The defense has not had a chance to look at that.
I will just say that, assuming that the defense doesn't go along with that, which I doubt they will,
Yes.
I would point out that it's not that there's anything wrong with your points and authorities, but I would also point out that the evidence that I have let in for the people, that also goes back a number of years.
I'm very well aware.
So I would be leaning towards not granting the people's request, and you can keep that in mind before you file a lengthy response.
Mr. Bruno and I had already talked about the fact that we come up with, we find a felony that they should have given us, now they're moving to exclude it. It's very ironic. Usually we're on the fighting end of that.
I am aware, and I'm sure the people have done what they
We're aware of
want.
all the.
Okay, there's equities involved here.
Yeah.
We'd be willing to let some of this ancient evidence go, including that, if they would reciprocate.
For those who are sitting in complete lost fog in the audience, the prosecution is seeking to have me exclude a prior felony conviction of one of their witnesses. It is an old conviction, and for the reasons I have just stated, I am not leaning towards granting their motion. And therefore, in all likelihood, the witness will be impeached with that prior felony. Anything else?
Thank you.
I'll see you tomorrow morning at 9:30. Thank you.
Okay, now we're back. Now we're back in front of the jury. But as always, for some reason, Court TV's website does not like it when it switches to the next section. I don't know why. So I'm going to have to fiddle with it. Yeah, Carla, I've been trying to figure out how to do it all morning. I got that one to work, but you couldn't tell what it was. And I tried with a bunch of different pictures and I couldn't get it to work, and I was just like, okay, I'm done until I watch some videos on how to do it. And I'd rather do this than watch videos on how to make emojis. So I was like, nope, I'll do it later. Come on, Court TV. At least it's not StreamYard this time. Come on. I put too much protein powder in my protein shake, and it's really thick. Because I forgot I put it in, and I put more in. Unmute, you stupid thing. Thank you.
Judge presiding.
All right, the record will reflect that defendant is present with his counsel. The district attorneys are.
If you recall, I had asked the court to take a look.
Dang it. Court TV, why do you do this to me? I guess it's not just Court TV, it's StreamYard too. Dang it. Yeah, I'm gonna have to ask Bill. What is happening? Come on, Court TV. Why is your website so wonky?
The record will reflect that defendant is present with his counsel. The district attorneys are present. Are we ready for the jurors?
Almost.
Okay.
Your Honor, if you recall, I had asked the court to take a look at the transcription of tape recorded phone messages for the next witness, which is Ms. Jennings. And I think we did hand it up to the court, and the court said we wanted to look at it, and then we hear argument.
Okay.
Rule. The one point that I did want to make this morning about it, Your Honor, is this. I suspect that, and I anticipate that Ms. Jennings will be addressing two incidents. And this really has nothing to do with either of them, because this transcription of these two phone messages fall between the two incidents, alleged incidents. And therefore, I don't think it has anything or any bearing on either of them. It certainly doesn't have any bearing on when she's being offered under 1101B. And also, as I made my argument earlier, I indicated to the court, I'd ask the court to exercise its discretion in 350 prejudicial effect on this. It's a very prejudicial pair of phone messages. It has no bearing on what I believe her testimony is going to be, either regarding an incident in September of '94 and then an incident in January of '95, neither of which have anything to do with the phone message, which appears on the December 24th date, which is sandwiched in between those two. And actually, if you look at the content and the subject matter, it really doesn't have anything to do with either subject matter that she will be addressing in her testimony. So there's a foundational argument, there's a materiality and a relevancy argument, and under 352, there's an argument there on the probative value versus prejudicial effect. And we'd ask the court to exclude.
Thank you. People?
Very briefly, I think the easiest way to handle this for the court is to hear her testimony first before you can completely synthesize where, if anywhere, this fits into a relevancy argument. With regard to 352, obviously the jurors have already been privy to certain foul language on the part of the defendant. If that's the 352 argument, I think that falls flat, that this is a murder trial, that they're going to hear a lot worse than the F word or something like that. With regard to relevance, I think the court should hold in abeyance any ruling on this particular phone message or set of phone messages until Ms. Jennings testifies. And it may be that it doesn't come up in our case in chief, rather in our direct examination. It may become relevant based on the cross-examination. I simply don't know.
Thank you, Mr. Rosen.
Well, just simply put, I heard Mr. Jackson's argument, but part of his argument didn't address my point, which is how is it relevant to either incident? And the reason he didn't address it is because I think he was unable to address it because it doesn't. It has nothing to do with either incident. And I think we should get a ruling now. I mean, she's about to walk up on the witness stand and testify, and I think we need to know where we're going with this.
Well, I think the bottom line is I can't rule till I hear her testimony. On its face, if indeed it doesn't relate to the incidents that everyone believes she's going to testify to, I would agree with you. It has nothing to do with the case, but it may, based upon either direct or cross. Right now, it appears I agree with you. I have to hear all the evidence. I'm not going to make an absolute ruling and then find out that there is something relevant and you say, gee, we're caught by surprise. I'm telling you that until I hear all of her testimony, I don't know if this will be relevant.
Would it assist the court in any way if I made a, we'll call a reverse offer of proof here as to what I think the two incidents are?
Yes, if you want, I'm not going to preclude you, certainly.
There's two incidents, Your Honor. I expect and I anticipate based on the receipt of discovery that she will testify that in September of '94, she was at Mr. Spector's house, and I believe her testimony is going to be that she was unable to leave for a period of 2 or 3 days. There was no weapon involved whatsoever, and ultimately she was allowed to leave. That's all plain and simple. Then there's going to be other testimony regarding what's been termed by the prosecution and the defense team as the Carlisle incident, and that's basically a situation which occurs after the fact. As you can see from the transcript on page 3 at line 5, this is dated December 24th of 1994. So this clearly has no relevancy to that because the Carlisle incident occurs on January 13th of 95. So therefore, this precedes that. It wouldn't have any relevancy to that. And secondly, this follows 3.5 months, about 3.5 to 4 months later from the September 94 and doesn't reference it at all. It has nothing to do with it. So I hope that maybe with that short offer of proof that will help the court in resolving this issue.
I think basically what it's done is solidified my opinion that I need to hear the testimony, that on its face, it appears it probably is not relevant, and that's where I'm going to leave it until I hear the testimony.
Okay, very well.
All right, let's proceed. Let's bring in the jurors, and let's proceed with the case. All right, the record will reflect the jurors and the alternates are present. People have another witness?
We do, Your Honor. We're going to ask Stephanie Jennings to join us, please.
All right.
Please raise your right hand to be sworn. You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Please be seated. Please state and spell your first and last name for the record.
Stephanie Jennings, StephanieJenninges.
Thank you. Why don't you sit back, pull the microphone underneath your chin so you don't have to lean forward, and you may proceed, Mr. Jackson.
Thank you, Your Honor. Ms. Jennings, thank you for joining us this morning. I want to draw your attention immediately back to April of 1994. Where were you living back then?
In Philadelphia,
And what was your occupation?
a photographer.
Were you employed by any particular agency, or were you what in common parlance is known as a freelance photographer?
Mainly freelance, but I did have an agency.
In 1994, in April of that year, did you attend the Philadelphia Music Alliance Awards ceremony?
Yes, I did.
Describe for the court what the Philadelphia Music Alliance Awards ceremony was.
Mainly, Philadelphia has a lot of musicians that they honor, and they give a big production, and there's a dinner, and Phil Spector was the keynote speaker, I believe.
Okay, you may have just answered my next question. When you look to your left, who are you looking at when you said Phil Spector?
At Phil Spector.
And where is he seated? What is he wearing right now?
A gray suit with a black shirt.
Indicating the defendant for the record.
Thank you, Your Honor. That sort of presupposes my next question. I was going to ask you, did you meet anybody that you see here in court today? Did you, in fact, see or meet Philip Spector at that event back in April of 1994?
Yes, I did.
And what was the connection between yourself and Mr. Spector?
After
Do you understand that? Can you answer that question? Just answer me yes or no.
yes,
The objection is overruled.
after I took pictures, I was introduced to Phil Spector.
Was that the first time that you had ever met him?
Yes,
Previous to April of 1994, did you know who Phil Spector was?
a little bit, not any details.
When you say a little bit, who did you believe he was, Philip Spector?
A producer,
Music producer or film producer?
music producer.
All right. Now, do you recognize, Your Honor, I'm showing what appears to be a photograph. It's probably a 35 millimeter photograph bearing a photograph of two individuals. I believe people's next in order may be 5.
I think it's 4, but let me double check to make sure I didn't miss one.
5.
It's 5. What was People's 4?
People's 4 is the CD that goes with Transfer People's 3.
Thank you. Let me make a note of that. People's 5 then. Thank you.
Thank you, Your Honor. Take a look at the photograph that's being displayed on the screen. Tell me if you recognize the people that are in that photograph.
Yes, I do.
Who are those people?
Myself and Phil Spector.
When was that photograph taken approximately?
I believe late in 94 at the Philadelphia Music Conference.
So this was not taken at the April event, but sometime after that.
Correct.
Now, Ms. Jennings, I noticed that with regard to the photograph that's taken back in 1994, there's a little bit of difference in you today as opposed to back then. Can you explain that for the court?
I had a car accident
When?
close to 2 years ago.
It just explains the difference. The objection's overruled. You may answer the
Go
question.
ahead and explain for the court, please.
I was in a bad car accident. I totaled my car.
Okay, and did that impact your face at all?
Yes.
Okay. I'm very sorry about that. With regard to that April 1994 event, other than the single introduction that you said you had with Mr. Spector, did you have any other contact with him at that event?
At that event?
At that event. All right. When was the next time, if ever, you came in contact with Philip Spector?
I believe a month later at Elaine's restaurant
Where is Elaine's restaurant?
in New York.
What were you doing in New York?
I was just visiting a friend.
Did you work in New York sometimes?
Yes.
Did you, I'm sorry?
My agency was in New York.
Okay,
My
so
photo agency.
was it unusual for you to go back and forth between Philadelphia and New York?
Not at all.
And for those of us that live out here on the West Coast, how far apart are those two cities?
An hour
By train, by car?
by bus, train, or car.
Okay, planes, trains, or automobiles?
Exactly.
All right. Explain the circumstances in which you came in contact with Philip Spector about a month later.
I was having a drink at the bar with a friend, and I went to the bathroom. And as I was coming out, so was Phil Spector coming out of the men's bathroom. And I'd recognized him from meeting him the month earlier. And I tapped him on the shoulder and said, "Oh, I just took pictures of you in Philadelphia."
And what was Mr. Spector's first comment to you?
Overruled. You may answer.
Was, "I almost just shot you."
He said, "I almost just shot you."
Yes.
Did you know what to take from that comment?
No.
Excuse me, question's been answered, Your Honor.
The question has been answered.
How did you react to that comment? Well, I almost just shot you.
What do you mean? And he said, if they're going to come and get me, that's how they're going to do it. And I took that to mean,
Excuse me. Relevancy.
The question has been answered.
What did you take that to mean?
Objection, relevancy.
What's the relevancy of that? What you thought it was?
Your Honor, if there's any ensuing conversation, it certainly would give context to the ongoing conversation.
With that in mind, ladies and gentlemen, I'm going to limit this particular question, or the answer, for the truth of the matter asserted, but only to explain the rest of the conversation that apparently is going to be coming in. You'll not receive it for the truth of the matter asserted. You may proceed.
Excuse me, Your Honor.
Yes.
Based on discovery, I don't believe there is any conversation.
Well, we'll see, or to explain what happened. The bottom line is not being received for the truth of the matter asserted. You may proceed.
Thank you, Your Honor. And I don't know the answer. Tell me, was there any additional conversation after that?
he asked if I would join his table for a drink.
All right.
Strike.
The motion to strike is denied.
Did you in fact join him at his table for a
Yeah.
drink?
Yes, I did.
All right. Tell me about that evening when you joined him at his table. Was there anybody else there? Were you alone? Was he alone?
There, my friend had left the bar, and there were several people at his table for a drink.
Do you remember any of the people at his table?
Offhand, I can't remember who all was there now.
All right. How long did you join him for that drink, if you will, at his table?
It was till after the restaurant closed.
Did you have dinner?
No,
After the restaurant closed, did you leave Phil Spector's company at that point, or did you continue to see him throughout the evening?
we continued to his hotel.
Describe that for us. What happened?
He asked if I wanted to, everybody at the table, if we wanted to go back to the hotel and continue to drink.
So not just you, but the whole group.
Yes,
Did you in fact join him back at his hotel?
yes.
What hotel was that?
The Carlisle?
About what time was it that you and the rest of the group went back to the Carlisle Hotel?
It was after Elaine's closed, I would say between 2 and 3 a.m.
Describe the mood of the group, if you will, the demeanor of the group, if you can do that for me.
It was fun. Everybody was having a good time, joking and laughing.
All right. What happened once the group, and I think you indicated that you don't remember exactly who was in the group, but do you remember how many people were in the group?
I would say at least 4, maybe 5.
Did all 4 or 5 of you go back to the hotel together?
Yes.
Okay. How far was it from Elaine's?
It's not very far, maybe a 10-minute ride.
A taxi ride?
We were in a limo.
Okay. Once back at the hotel, did everybody go up to Mr. Spector's suite or room?
Yes.
And what happened once there?
There was piano playing, singing.
Were you singing?
No.
Were you playing the piano?
No.
All right. So there were some other people there that more musically inclined than yourself.
Yes.
All right. What happened back at the hotel other than singing and piano playing?
We're drinking.
Okay. How many people ended up staying the whole night?
I believe just myself.
Okay. The next day, well, let me ask it this way. Was this the first time that you had had any social interaction with Philip Spector?
Yes.
All right. And did he ask you to stay the night?
Yes, he did.
Did you agree?
Yes.
All right. At no point during that evening did you say, I'm ready to leave or I want to leave?
No.
All right. The next morning, what happened?
I left during the afternoon.
I don't want to be indelicate. During the course of that evening, did your and Mr. Spector's relationship turn intimate?
Yes.
All right. Was that the beginning of a dating relationship?
Yes.
How would you describe that dating relationship between yourself and Philip Spector back in 1994?
It's kind of a long distance relationship.
Did you know where Mr. Spector lived permanently at that time?
Yes.
Where?
In Pasadena.
Is that because he told you that or you had visited him there?
I visited him there later, but because he told me that.
I'm talking about in 1994.
He told me.
Okay. Did you know whether or not Philip Spector also maintained some residence in New York?
I thought he had shared the suite at the Carlisle with, I guess, Princess Diana, like they both took shares.
At the same time?
No, separately, like they both shared it.
So both individuals might stay at the Carlisle Hotel in this particular suite at different times?
Correct.
Did you know whether or not Philip Spector would stay for an extended period or extended periods of time in New York?
No, I don't know.
You don't know or he didn't?
I don't know.
All right. When you would see him, was it mostly, and I'm talking about during the course of your 1994 relationship, when you would see him, was it mostly on the East Coast or did you fly out here to the West Coast?
Mostly on the East Coast.
All right. After that first night, did Mr. Spector indicate whether or not he wanted to stay in contact with you?
Yes.
How did he so indicate? What did he say?
He told me he'd like to. Could he call me?
Did you give him your number?
Yes, I did.
Did you two begin a telephone relationship, if you will?
Yes.
And you've already indicated that it was somewhat long distance. So were there cards and letters and telephone calls written back and forth and made to each other?
Yes.
How long did that go on?
I believe a year and a half, 2 years.
All right. In total?
Yes.
I want to draw your attention to January of 1995, January of the following year, all right? Did you receive any kind of an invitation from Philip Spector to attend the Rock and Roll Hall of Fame induction ceremonies or the Rock and Roll Hall of Fame induction ceremonies after party?
Yes, I did.
Describe that for us. When did you receive that invitation and how did you receive it?
He had called and asked if I would like to go and that I'd have my own room at the hotel at the Carlisle.
Were you still living in Philadelphia at the time?
Yes.
Okay. And what happened?
And yes, I said I was interested, and he said he'd have his assistant get in contact with me with all the details.
Were you still working as a freelance photographer?
Yes.
Did you have any focus insofar as your photography was concerned, the subject matter?
That was a big focus of going to the party.
Tell me what as a photographer, what interest would going to the Rock and Roll Hall of Fame induction ceremonies have for you?
I would be able to photograph the artists that I sold the pictures of.
Was that important to you professionally?
Yes,
Was it also convenient for you socially to see Philip Spector in a social atmosphere at either the induction ceremonies or the after party or both?
yes.
Tell me about how you got to New York for that particular weekend.
Phil had sent a limo for me.
To Philadelphia?
Yes,
And so that you then joined him after that hour-long ride in New York.
yes.
Did you join him at the induction ceremonies themselves?
No, I went to the hotel and checked in and changed and got ready for the party.
Do you remember who was being inducted, a notable figure that was being inducted in January 1995?
I'm not sure with the 2 years if it was when Peter Wolf with the Jay Giles Band and Neil Young, if it was that year that they were getting inducted.
Okay, but you do remember Neil Young being one of the inductees at some point?
Yes,
All right. Once in New York, and I'm sorry, I may have just asked you this and interrupted you. Did you in fact attend the induction ceremony or just the after party?
just the after party.
Okay, where was the after party?
It was at the Waldorf Astoria.
And what hotel did Mr. Spector get you a room to stay at?
At the Carlisle.
Tell me about the party.
The party, there's just hundreds of people in the music industry. Phil was playing piano with lots of other people, Paul Schaefer, Lisa Loeb, Robbie Robertson. Everybody was singing around the piano, including Stevie Wonder. I have pictures of all of that.
That was my next question. Did you take your camera equipment?
Yes,
And this is professional equipment?
yes.
How much equipment would you estimate that you took with you?
Just one camera on my shoulder,
Was that and you're talking about at the
35
actual,
millimeter camera.
I'm sorry. I'm going to be very careful. The court reporter is going to kill me if we talk over each other. So make sure you wait till the end of my sentence before you answer me. At the actual party, you just have 35 millimeter camera?
Correct,
Did you have additional equipment back at the hotel?
yes,
Had you already checked into the hotel before you went to the party?
yes.
How much additional equipment did you have with you back at the hotel?
My entire camera bag.
How much, well, was it a bag that contained just lenses or a bag that contained a couple of camera bodies and lenses or?
A couple camera bodies, lenses, flashes,
Okay, so a substantial amount of equipment.
yes,
Is that the normal stuff that you would bring with you as a professional photographer to a particular event?
yes,
All right. Did you check into your room at the hotel before you joined Mr. Spector at the party?
yes.
During the course of the evening, well, did you go with him to the party or did you just meet him at the party? Or do you remember?
I went with him to the party.
All right. Was Mr. Spector staying at the same hotel that he'd given you a room at the Carlisle?
Yes,
Was he staying on the same floor that you were staying at?
yes,
Were you two sharing the same room or no?
no,
Once at the party, you said there was a lot of singing and playing piano, et cetera. There were some notable figures at this party, correct?
yes,
Was there any drinking going on?
yes,
Did you see Philip Spector consume alcohol that night?
yes.
Describe that for us.
He was drinking mainly vodka. So,
If you had to give an estimate as to the quantity of alcohol that Mr. Spector consumed throughout the evening, could you do that for us?
I don't know what the estimate would be, but I never saw him without a drink.
The answer was, I can't give you, I may be paraphrasing, I can't give you an estimate, but he was never without a drink. He was never without a drink.
Thank you, Your Honor. May I?
Yes.
At the beginning of the night, could you describe Mr. Spector's state of inebriation or sobriety? Do you understand my question?
He seemed fine.
Okay. Toward the middle of the evening, could you describe that for us?
He had a lot more to drink. He was getting, in my opinion, a little drunk.
Toward the end of the evening, describe his state of inebriation or state of sobriety.
Extremely drunk, obnoxious.
When you say extremely drunk and obnoxious, describe the demeanor that you're trying to get across to the jurors.
Just very loud, insulting.
Did you hear him speak?
Yes,
Were his words slurred in any way?
yes,
Did you see him walk?
yes,
Was his gait, and when I say the word gait, I mean walking, was it steady or unsteady?
unsteady.
Did he appear to you, based on your experience with Mr. Spector, that he was in fact toward the end of the evening drunk?
Yes.
What happened toward the end of the evening with regard to you being at that party?
I was ready to leave. I hadn't seen Phil in probably an hour towards the end of the party. Almost everyone was gone, and I was tired. I was ready to go, and I couldn't find him anywhere, so I walked down the steps to the front of the hotel and took a taxi back to Carlisle.
Did you just go back to your room by yourself?
Yes.
And what did you do once you were back at the room?
I went to sleep.
What happened next?
There was a knock at the door, and it was his bodyguard.
Did you recognize his bodyguard? How did you know this individual?
Earlier in the evening, before we left, he had taken a couple Polaroid pictures of Phil and I together.
He, the bodyguard, had?
Yes.
All right, so you had met him earlier the evening.
Yes.
What did the bodyguard say to you when he knocked on the door?
That Phil was requesting that I go over to his room.
About what time was this?
I would say between 3 and 4 in the morning.
At the time that the knock came on the door, were you awakened out of a sleep?
Yes.
And what was your response to the bodyguard when he said, Mr. Spector is asking for your company down in his suite?
That I was sleeping. I would see him in the morning.
Did you go to Mr. Spector's suite at that point?
No.
Did you shut the door?
Yes.
And what'd you do?
Got back in bed.
Then what happened?
There was another knock at the door.
What did you do then?
I got up and answered the door.
How long between these two knocks at the door?
5 minutes.
How far was Mr. Spector's room from your room?
I'm not exactly sure.
Was it on the?
It was on the same floor, but I'm not sure where on the floor.
Okay, so assumably down the hall or down a hall somewhere.
Yes.
Well, but given the possibilities, that is the only assumption, somewhere down a hall somewhere. So I'm going to overrule. If that's an objection, it's overruled.
Who was who was at the door when the second knock came?
Phil was.
Philip Spector?
Yes.
And what happened?
And he came in the room and asked for me to come over to his room.
Describe his demeanor when he asked you to come down to his room.
He was definitely drunk, and he was loud and demanding that I come over to his room.
And what was your response?
No, that I wasn't going to.
And what did he do or say?
That he was paying for the room. If I wanted to stay, then I would go over to his room.
Did he say this in a nice way, or did
No.
he describe his demeanor as he was saying this?
He was getting angry and loud.
Did Phil Spector come into your room at that point? Or was
Yes.
this conversation at the doorway?
He was inside the room.
All right. What was your response when Mr. Spector said, I'm paying for this room and you'll come down to my suite if I tell you to?
I said then, well, I'll pay for the room.
So what happened?
And he said, then go pay for the room. And I said, fine. And I was trying to get all my equipment together and pack. And he said, you'll leave your bags here.
Why were you packing your equipment?
Because that was important to me and I wasn't going to leave anything there. And I said I would take my bags to the front desk and go take care.
Any questions?
I don't think it has. You may continue.
Go ahead.
I said I would take the bags down to the front desk and go take care of getting the money and paying for the room.
Was it your intention, based on Mr. Spector's comments and the argument that ensued, to leave that room?
Yes.
Was it your intention to take your belongings with you when you left?
Yes.
Did you tell him that that's what you were going to do?
Yes.
What did you say with that regard, if you recall?
That I wasn't leaving my bags in the room. I would leave them at the front desk, but I was not leaving them with him.
Did you indicate to Mr. Spector it was your intention, based on the argument, that you were going to leave?
Yes.
All right. What did he say when you said you were going to leave?
That the main thing was then I would have to pay for the room.
What did he say with regard to your camera equipment, your bag, your luggage?
I had to leave it there.
Overruled.
What did you begin to do as this argument erupted?
I was trying to finish packing everything up. I had everything packed up but what was in the bathroom.
And what was Mr. Spector doing at this time when you were packing things?
He was following me around, yelling at me.
When you say yelling, what kind of things was he saying?
I don't remember exactly. At this point, I was starting to cry and get very upset.
Was he saying nice things like, let me help you pack?
No.
Was he calling you names?
Yes.
Was he using foul language?
Yes.
Do you remember any of the language that he used specifically?
She's already answered, so she doesn't remember the
She did, but she may recall something. The objection is overruled.
Specifically, I don't remember at this point because I was getting very upset and crying and just trying to get everything together.
At some point, did you go into the bathroom to begin
Right,
putting
that's-
together your
that was-
sundry items?
Right, that was the last thing I hadn't packed. So I was in the bathroom putting everything, all my makeup and everything together.
What happened when you went into the bathroom?
He came in after me and I don't know if he slapped me or pushed me, but there's physical altercation.
When you say a physical altercation, Ms. Jennings, are you saying that you turned on him and got physical with him, or he got physical with you?
He got physical with me and I in turn then shoved him.
All right, we'll get to that in a second. When you say he got physical with you, do you mean he just grabbed a wrist or grabbed your night clothes or slapped you or hit you, or what did he do?
I'm not sure exactly if he slapped me or pushed me, but I ended up kind of falling backwards, like on the toilet.
And what did you do in response?
And then I jumped up and I grabbed him and I pushed him and he fell into the bathtub.
Was there a shower curtain?
Yeah,
Did the curtain come down?
yes,
Did he go completely into the tub?
more or less, yes.
And what happened after you pushed Mr. Spector into the tub?
He got up and left the room.
Did he say anything to you before he left the room?
No.
What happened next?
Then as I was finishing, I packed everything, I had it on the bed ready to go, and he came back in the room.
Were you still crying at this point from the argument and from the altercation?
Yes, I was just trying to rush around and decide, what I needed to do.
All right. What happened when Mr. Spector came back into the room?
He had his gun with him, and he pulled a chair and put it in front of the door and said that I wasn't going anywhere.
Describe the gun that Mr. Spector had with him when he came back into that hotel room.
It was a small gun. I'm not sure exactly what type of gun it was, but it was a small handgun.
All right. Do you remember if it was chrome or black or any specifics about it?
Right now, I don't recall
Do you know
the
the
exact
difference?
specifics.
I'm sorry, I didn't mean to step on your words. Do you know the difference between a revolver and a semi-automatic weapon?
I do now.
Did you then?
No.
As you think back in your mind's eye to the event back in January of 1995, do you now have an idea as to whether or not that gun was a revolver or a semi-automatic weapon, or do you know?
I'm not 100% positive.
Okay. When Spector walked into the room with this gun, did he point it at you?
Yes, he did.
Did he order you to do anything?
No, he just sat in front of the door and said I wasn't leaving.
When you say that Mr. Spector sat in front of the door, was there already a chair in front of the door, or did he move a chair in front of the door?
He moved a chair in front of the door.
Did he shut the door behind him when he came into the room?
Yes,
So literally, he pulled the chair out, set it in front of the door, and sat down in it like I'm doing right now?
yes.
Did he have the gun out in front of him?
He had the gun all over the place.
Was he pointing it in your direction?
He had,
It's been asked and answered.
The objection is overruled.
yes, he pointed in my direction.
How did that make you feel, Ms. Jennings?
That I was about to get shot, that I didn't know what was going to happen.
And what was your reaction when Mr. Spector pulled this gun on you and sat in front of the door?
Well, I sat on the bed, crying, trying to decide what to do, and he didn't seem to really be paying attention to me sitting there, and so I picked up the phone and dialed 911.
Did you say anything to him to try to indicate your desire to leave or anything like that?
Yes, I mean.
What were you saying?
That I just wanted to leave and that I would put my bags at the front desk and I would take care of paying for the room.
And what was his response while he had this gun in his hand?
That I was not leaving the room with my bags. And my main concern was my camera equipment.
Were you also concerned with your personal safety?
Yes, of course.
Did you say anything to him before you picked up the phone about who you were going to call or what you were going to do?
No.
What did you do with regard to that telephone in the room?
I picked the phone up and dialed 911. And for some reason, he thought I was calling my mother.
How do you know that? How do you know what he was thinking?
He made the comment that you can call your mom all you want. She can't help you now.
Is it your impression that he did not realize that you were calling for 911 emergency?
No, he did not.
Did you get a hold of a 911 operator?
Yes.
And what did you tell her? I realize that you may not have a memory of exactly the words that you used, but generally, what were you telling the 911 operator?
Whoever the operator was excellent. I didn't have to tell her anything. She asked the questions that all I needed was to say yes.
Objections to what she said. I'd ask for a limiting instruction and turn your testimony on the operator said.
Fine. Is there any conversation between the witness and the operator? It's limited, not for the truth of the matter asserted, but to explain what the operator did and what the witness did. You may proceed.
Thank you.
Thank you, Your Honor. During the course of this conversation, you indicated or you started to explain that the operator didn't require you to say a whole lot. Tell me the gist of the
No,
conversation.
actually, just excuse me. I'm going to change my ruling. It's an excited utterance. There is no limitation. Ladies and gentlemen, you may consider this testimony without limitation. You may proceed.
Thank you, Your Honor. What was the gist of what you were saying to the 911 operator and the gist of what she was saying in response? I'm assuming it was a she. I probably shouldn't.
Yes, it was a she.
Okay. Tell me the gist of this conversation.
She asked if this was a domestic dispute. She asked if I was calling from the Carlisle. She asked if the person had a weapon, if it was a gun, if I was in fear for my life. And as I was answering all these questions, she said the police would be coming.
Were you answering mainly yes,
Yes.
no, yes, no?
Correct.
Is there a reason that you didn't just come out and verbally explain the whole of the incident?
He was sitting right there.
Did that scare you?
Yes.
Did you believe that you might incite him in some way?
Yes.
Did you explain to the 911 operator that it was Phil Spector?
When there was kind of a little bit of a commotion out in the hallway, and he got up and went to leave, and then I said to the operator who he was and what was going on.
All right. So at some point, you were able to give a little bit more detailed information to the operator when you felt that you were more safe because he was out of the room.
Yes.
During the course of the beginning of the conversation, was Philip Spector still sitting in front of the door with the gun in his hand?
Yes.
Was he still pointing it in your general direction?
Yes.
Was he saying anything while you were on the phone with the 911 operator?
Not after the comment he made.
Okay,
about
not
my
after
mom.
about the mom.
Yes.
Okay. You indicated that there was some kind of commotion that caused him to leave. Describe that for us.
It sounded like the elevator doors opening and people starting to come out of the elevator.
And what, in fact, did you see Philip Spector do when this noise emanated from the hallway?
He left the room and went out the door.
Did you see what he did with the gun before he left the room?
No, I did not.
At some point, did the police arrive in your room?
Yes.
And what happened next?
They asked what was going on, what I wanted to do about the situation. Some of them, there was several police officers, and they brought the hotel manager up, and they were.
It may have, it may not have. Let's go ahead and finish, and if it appears that it's straying too far away, I'll strike it. You may proceed.
And repeat the question.
You were
please.
indicating that the police did in fact arrive. They asked you what had happened, and also some hotel manager or security, somebody showed up as well.
Yes.
What happened when these individuals made contact with you?
Some came in my room, and some were out in the hallway, and they were asking, exactly what was going on. And I told them, and I handed them my business card, and I had my camera equipment, and I just felt like they weren't treating me, they were treating me as if I was a call girl. They weren't taking they weren't taking what was going on seriously.
Did you tell them that the incident involved Philip Spector?
Yes,
And this is the same Philip Spector that shared a suite at this hotel with Princess Diana?
That's
a misstatement of the evidence.
excuse me. Thank you. The question is stricken. The jury's admonished to disregard it, and you may proceed.
With regard to your conversation with hotel security or hotel management, as well as the police, did you indicate that this was, in fact, an incident involving Philip Spector?
yes.
Did they appear to know who Philip Spector was?
Objection, cause for speculation.
No, there may be something that they did, may not, and we'll see what happens. You may answer the question.
Well, may I also, for the record, impose an objection on hearsay grounds?
The objection is overruled. You may proceed.
Yes.
How do you know that?
They had been up to the rooms previously.
I'm going to object to this.
It's the basis for her belief that they knew who she was talking about, or they knew Philip Spector. There may be a basis for it. I believe she's explaining they were there at some time with him present. Maybe not. Were they there with him present?
Not at that time. Previously, when we were over at his room with the piano playing and everything, they had come in. And so it was the same people. I believe they know exactly who he was.
Okay.
Well, it's speculative.
Well, as to who he was, that's a very broad category. As his background, perhaps not, but you believe he was present when they were there at an earlier time.
Yes,
All right. With that will remain. You may ask your next question.
Thank you, Your Honor. You indicated that you didn't feel like they were taking you seriously.
correct.
What did in fact happen when you explained the story to them?
They just wanted to, what I wanted to do. Did I want to press charges? I was very upset and crying at this point, and I didn't know what I should do. I asked, should I press charges? What should I do?
What was the
And
response that you got?
basically, why don't I come down to the office, the hotel office?
Did you join these folks down at the office?
Just the hotel manager.
And what happened then?
And he gave me money to take the train back to Philadelphia.
Did you feel like, was it your impression, and I'm not asking you what their impression was it your impression that you were just being quietly scooted out of the hotel to leave things lie?
Yes.
Excuse me.
Yes.
There's an irrelevancy objection.
At this point, based upon how the question was asked, the objection is sustained. The answer is stricken. The jury is admonished.
Did you leave the hotel that night?
Yes.
Did you in fact press, as you understand it to mean, press charges?
No,
In other words, did you follow up with any indication that you wanted criminal charges filed?
not criminal charges.
Why?
I really didn't know what to do. I just wanted to get out of there with my equipment and myself.
Was that your main goal?
Yes,
Ultimately, you made it back to Philadelphia.
yes.
After this incident, did you have any more contact with Philip Spector, either telephonically, in person, otherwise?
Yes.
Did Phil Spector ever mention this gun incident with you again?
No,
Did you ever bring it up?
no.
Why not, Ms. Jennings?
I just felt it was the best thing to not bring it up.
What was the nature of your contact with Mr. Spector after this event?
He had asked me if I wanted to go to the same event the following year.
Did you agree?
Under the agreement was I really wouldn't even see him. I'd have my own room. I'd go to the party, and he would be leaving directly after the party.
Did you in fact go to that Rock and Roll Hall of Fame party the following year?
Yes.
Did you go with Mr. Spector this time?
No.
What was your reason for accepting an invitation a year later after this event had happened?
As a photographer in the music industry, that's the type of event I needed to be at.
How did you feel about the idea of making contact with Philip Spector after this event? In other words, being alone with him versus being in a crowd with him.
I didn't feel I'd be alone with him. Well, I was not going to be alone with him.
Did that have any impact? Well, the fact that you believed you were not going to be alone with him, did that have any impact on your decision to accept his invitation to go to the party?
Yes, if I wouldn't have had my own room, and basically he had said I wouldn't have any contact with him, he would be leaving directly after. If that wasn't the case, I wouldn't have gone to the event.
At some point, did your relationship with Philip Spector, well, let me ask it this way. After this incident, did you have any further romantic relationship with Philip Spector ever again?
Not after those events.
After January of 1995? In other words, did you maintain a romantic relationship with Mr. Spector after January of 1995?
I don't believe so. Check the dates.
Well, with regard to using the event at the Carlisle Hotel where he pulled a gun on you, do you remember what the nature of your relationship was after that?
It was just over the phone.
All right. Were you ever alone with him again?
No,
Did you ever spend the night in his hotel again?
no,
Were you ever at his house?
not after that.
When was the last time, let me back up and ask one precursor question. At some point after the second year that you went to the Rock and Roll Hall of Fame after party, okay, not the incident at the Carlisle, not the gun incident, but the following year. After that, were you invited to any kind of an event by Philip Spector?
The last time that I heard from him, he had called while he was in the studio with Celine Dion and had asked if I wanted to fly out and take some photographs while they were in the studio.
And did you agree?
I said I would like to in a couple of days, but I couldn't leave that day.
And what was his reaction?
He wanted me to leave that day.
Did you tell him you would or would not?
I would not leave that day.
So what happened after that with regard to your relationship?
So then that was it. If I wouldn't leave that day, then it was done.
That was the last time you talked to him.
Correct.
I'm going to take you back in time just a little bit. Was there ever an invitation to a birthday party?
Yes.
Was it prior to the Celine Dion invitation?
Yes.
And tell me about the invitation to the birthday party.
I was.
I don't think we need to. It shows a relationship post the Carlisle incident and prior to having no further conversations with him. That's relevant in my mind. There is no further foundation that need to be laid.
Well, just the way the text phrase, I'm not sure it's post-Carlisle.
I just asked Mr. Jackson. He nodded to me. Based upon that it is post-Carlisle, the objection is overruled.
I'll just ask the witness, after the Carlisle Hotel incident, and when I say that, I'm talking about the incident with the gun. I know you'd probably been to the Carlisle and other times, the incident with the gun. After that, was there an invitation to a birthday party?
There was an invitation to his birthday party.
Okay, tell me about that.
I was supposed to meet him as his date for his birthday party.
And did you?
No, I did not.
Why?
I had started seeing someone and I didn't feel it was appropriate. And I basically stood him up.
Did you hear from him after that incident?
Several times on my answering machine, several threatening phone calls concerning the event.
Concerning that particular birthday party,
Yes,
he left messages on your answering machine.
yes.
Were these kind in nature or otherwise?
No, they were horrible.
Describe them for me.
They were threatening, calling me names I had not been called before, said I would never work again in Philadelphia. He was that good at what he did, and he could make sure that I would never work again.
Was it after this, and I'm going chronologically now, was it after these threatening phone calls, these messages that were left on your answering machine, was it after that he then asked you if you would like to photograph the Celine Dion recording session?
Yes, it was a while after that.
All right, and you declined to leave that day.
Correct.
After that, after you declined his request to come out that day regarding the Celine Dion incident, did you ever have any more contact with Phil Spector again?
No, I did not.
At some point, Ms. Jennings, did you hear about the death of Lana Clarkson in February 2003?
Yes, I did.
When was it that you became aware that Lana Clarkson had been killed?
I guess shortly after it happened, a friend of mine called and told me what she'd heard on the radio.
At some point subsequent to that time, when you realized that there had been a death, that Lana Clarkson had died, were you contacted by anybody who claimed to be a writer
Yes, I was contacted by many different media people.
All right. Describe the contact. Did you actually ever talk to one of these individuals or interview
Yes.
with one of these individuals?
Yes.
Tell me the nature of what this person said he was doing or she was doing.
Basically, a story on Phil Spector.
All right. And what was the reason that this person gave for contacting you?
He knew I had brought Phil Spector in to be the keynote speaker.
Well, when you say he knew, is this something he told you?
The writer,
Yes.
not only did he tell me, but he was at the Philadelphia Music Conference.
The objection is overruled.
Go ahead with your answer. What did he explain to you was his intention?
That he wanted to talk to me about, I guess, background on Phil Spector and use my pictures for an article that he was doing.
Did you agree to allow him to use, or at least agree initially to interview with him and discuss the idea of using some of your photographs?
Yes,
Did you know what company or what entity he was with at the initial?
at the initial no. I knew him from being at the Philadelphia Music Conference that Phil Spector was the keynote speaker at my request.
Did you in fact meet with this individual writer?
Yes,
And did you bring photographs with you to show this individual?
yes,
And that was for his, at least the purpose that you believed was for his use of those photographs in an article that he was writing about Phil Spector.
yes, and he took the photos with him.
All right. During the course of showing him, did you show him some of your photos
Yes,
at this meeting? During the course of showing you the photos, were you in fact photographed holding one of the photos?
he had brought a digital photographer in, and the photographer said he wanted.
Excuse me, it's not responsive.
It is responsive. Yes, would have also been more responsive, but explaining how the picture was taken, so I'm going to allow it.
It was actually that picture that's up there that he wanted to take a digital image of it, and I had a copy I wanted to just give him, and he said no, he needed to take a digital image. So he asked if I would hold the picture as he took it,
Okay.
and so when he didn't take just the picture of the picture, I'm in the picture also.
Did you believe at the time that you were talking to this writer that you were going to be the subject of an article?
No,
What did you believe?
that it was an article on the events that had happened.
Meaning the death of Lana Clarkson?
Yes,
Did you believe that your photographs might be used in an article about Philip Spector and the events of February 2003?
yeah, I was positive that they were going to be used.
Okay. Did you have any problem with that?
No, that's what I am. I'm a photographer.
All right. When was the first time that you saw, and by the way, did you later learn who this writer was writing for?
Yes,
Who?
the National Enquirer.
Did you in fact at some point see an article written in the National Enquirer?
Yes,
When was the first time that you realized that an article was being published in the National Enquirer and you were the subject matter of it?
well, when I read the article.
You had not previously been told that that was going to be the subject matter?
No,
Would you have agreed to interview with this writer had you known that you would be the subject matter?
no, I was not interested in being the subject.
Did he pay you for the use of your photographs?
He paid me $1,200.
Did you believe that that payment was remuneration for you being the subject of the article or for the use of your photographs?
For the use of the photo that he did use.
All right. On that same note, did you reach out and contact the police when you heard about this incident, or did the police contact you? Why are you here today?
Detective Tomlin had contacted me, or tried to contact me.
How did Detective Tomlin, and I'm assuming you're talking about Detective Rich Tomlin, one of the investigating officers on this case from the Sheriff's Department.
Yes.
How did Detective Tomlin attempt to get a hold of you?
He had called at work several times, and I was not interested in being involved, but he was relentless in calling, so I
Well, the
called.
Sheriff's Homicide people can be that way sometimes.
So I called my lawyer and told him what was going on and gave him the telephone number and asked if he would take care of the situation.
Did you in fact ever agree to meet with Detective Tomlin and interview with Detective Tomlin
Yes, I did.
and his partner?
Yes.
Are you here voluntarily because you asked to come here, or did our office subpoena you to be here?
Your office subpoenaed me.
If you had your choice, are there other places that you'd rather be than sitting on that witness stand right now?
Yes.
The objection's overruled. The answer will stand.
In fact, after you realized that you could potentially be a witness in this case, have you ever contacted any media outlet in any way, shape, form, or fashion and told them any story about, or given them access to any article?
No, the media,
Objections to the answer.
The answer will stand, and you may proceed with another question. If
Thank you, Your Honor. May I have just a moment?
You may.
Your Honor, may I have just a quick second?
Yes.
I may have been clear as mud about one incident, and Mr. Dixon has just brought it to my attention. If I wasn't super clear about this, or if you weren't super clear about this question, please. You indicated that while you were on the phone with 911, the 911 operator, at some point, Philip Spector got up from the chair, exited out of the door, and he went down someplace that you didn't see where he went, correct?
correct.
Did he ever come back in the room with that weapon, or was that the last time that he left with the gun?
That was the last time that he left with the gun.
Thank you.
Thank you. Just before cross, Cindy, do you want to take a break now, or would you rather start with cross? Take a break now? All right. We'll be, ladies and gentlemen, keeping in mind the admonition, we'll be in a brief recess. We'll resume in about 10 or 15 minutes. Thank you.
All right, Court TV, come on. Don't be stupid. I did wonder what was wrong with her nose, but it's not. I mean, it's noticeable, but it's not horrific. I mean, it's an easy explanation. I was in a car accident. Big deal. I don't even know why he mentioned it. I mean, is that supposed to be like, oh, well, Phil Spector wouldn't have touched her today because she's got a messed up nose? I mean, I don't know. I don't know what the point was. Well, like I said, the witness before her, she volunteered the information that she was under subpoena. Like, she wanted them to know she didn't want to be there. I think she was maybe a little more like she wanted Phil to know she was not there of her own free will. Can you please unmute? Can you please just unmute? That's all I want. Just unmute. Please. Thank you. And now it has paused itself. Play.
Come to order, court to get a session.
All right. Thank you. The parties and the jurors and alternates and the witness are present.
Good morning. What is your preference? address you as Miss, Mrs., or Ms.?
Doesn't matter.
Well, give me some direction here, okay? Because we're going to be together for a while.
How about Stephanie?
I can't, no, that I can't do. You made the one choice that's not allowed. We can't do it on a first name basis at the courtroom yesterday. I had the One thing also I would just caution you about, it's very much people's habits to go and and it's a nightmare for our reporters, Diana and Cindy. So if you would, if the question is a yes or no, you have to sort of say yes or no. It really helps us with the record, okay?
Sure.
Okay. Ms. Jennings, good morning. I want to start my examination this morning with talking to you about this incident that you alleged here occurred at the Carlisle Hotel, okay? And as I understand it, that was back in January of 1995, correct?
Correct.
All right. Now, I want to get right to the point where you indicated you were in your room, you had finished the evening's activities, and you were asleep, correct?
Correct.
And while you were sleeping, all of a sudden there was a knock at the door, correct?
Correct.
And you got out of bed and you went to the door, and it wasn't Mr. Spector at the door, but one of his bodyguards, correct?
Yes.
And you were aware of why he had bodyguards at that time, weren't you? Well, let me
No.
ask you this. You had learned that he had been beat up in a hotel room and that he had...
No.
It is irrelevant. The objection is sustained.
Okay. At any rate, you had a knock at the door. This gentleman requested of your presence down at Mr. Spector's room in another part of the hotel, but on the same floor, correct?
Correct.
I want to make sure. You had your room, he had his room, correct?
Yes.
Okay. And as I understand it, you shoot him away, you sent him on his way because you were sleeping, and you told him, I'm asleep, it's late, and no thank you, right?
Correct.
Okay. There was nothing, nothing occurred between you and the bodyguard that was out of line. He left, right?
Right.
He didn't try to force his way into the room, did he?
No.
And he certainly didn't get physical with you in any way.
No.
He didn't grab you and drag you down the hallway in your nightclothes.
No.
All right. You said, I think, in your testimony that about 5 minutes passed, and you heard another knock on the same door, correct?
Correct.
And you got out of bed again, I assume, and went to that door,
Yes.
and you opened the door.
Yes.
And when you opened the door, Philip was there, correct?
Yes.
Not the bodyguard,
Right.
just Philip. Is that correct?
Yes.
And you invited Philip into the room, correct?
I don't believe I'd invited him into the room.
Okay. At any point, at any rate, you and Philip wound up in the room. Is that correct?
Yes.
All right. And I think, as I heard you correctly, he invited you to come to his room, the room that was down somewhere, right?
Yes.
And you basically took the position, look, Philip, it's late. I'm tired. I've been to the music awards. I took a lot of pictures. I just want to go to sleep. Something along those lines, right?
Well, I was sleeping.
Correct. And when you told him that, he took the position that he still wanted you to come down to his room. There were people there, music going on. He wanted you to, for lack of a better term, join the party, correct?
I don't know if it was join the party or just join him. I took it to just join him.
Okay, but you don't know because you don't know who was in the room or who wasn't when he made the request inviting you down to the room, right?
Right.
Okay. And then, as I understand it, after he asked you to come to his room, which was the way you described it, you were emphatic about it and you said no, correct?
Correct.
And then, as I understand it, Mr. Spector had a discussion with you about paying for the room, the fact that he had paid for the room,
Yes.
and he wanted you to return to his room with him, right? Isn't that what happened next?
Yes.
Okay. And you indicated Mr. Spector was loud, right?
Yes.
He was angry, correct?
Yes.
He was talking to you in a heated voice, correct?
Yes.
And you were getting a bit concerned about that, right?
Right.
Okay. And as I understand it, there was some colloquy between you and Mr. Spector, and ultimately it wound up with Mr. Spector directing you to pack your bags and leave, right?
He didn't direct me to pack my bags and leave. I had already been packing my bags.
All right.
I was going to leave.
Okay, but there was a conversation between you and him about leaving and your baggage as well as paying for the room, correct?
Yes.
All right. And you indicated to him that you were not going to leave your bags up there, right?
Correct.
As I understand it, you said some of the things he was saying to you were not nice things. He was calling you names, and you became upset and you started to cry, correct?
Correct.
You were getting concerned, right?
Yes.
You started to become scared, right?
Correct.
As I understand it at that point, things changed geographically and you moved from wherever you were in the room itself into the bathroom area in the room, right?
That was the room I hadn't packed yet.
Correct. You wanted to collect your toiletries, pack them up so you'd have everything. You didn't want to leave them and leave the room, right?
Right.
Okay. And as I understand it, Philip followed you into the bathroom and he was talking at that time to you and you were talking to him, right?
I wouldn't call it talking.
All right. Yelling, screaming, angry words.
Yes.
And when you got into the bathroom area, as I understand it, things really escalated, correct?
Yes.
You indicated he put his hands on you, right? You don't remember exactly what, but you are clear he put his hands on you, correct?
Yes.
And you are also clear that in response to him putting his hands on you, you shoved him, right?
Yes.
And you shoved him with into the tub, correct?
Yes.
And down came the.
Yes.
I'm going to answer. At that time, I'm sure it's the same answer. How tall were you?
5 foot,
Okay, and what did you weigh?
100 pounds.
Okay, about the same as today, yes?
A little heavier
Close.
today.
Okay, well, I'm not going to ask much more. You'll get angry at me. Okay, so you push him. He falls into the tub. The curtains come crashing down. And his response is he gets up and he leaves, right?
Yes.
Doesn't smack you, does he? At that point when he got out of the tub, he leaves, right?
Yes.
Doesn't hit you. He doesn't put his hands on you. He leaves, right?
Yes.
Now, at that point, as I was listening to your testimony on direct by Mr. Jackson, I took it that you were starting to get pretty fearful. Is that true?
Yes.
Mr. Spector left the room. You finished packing. Mr. Spector returns to the room, correct?
Yes.
And this time you are alleging that he had a handgun with him, right?
Yes.
And as I understand it, you said he took a chair, he put it somewhere in front of the door area of the room and sat in the chair, right?
Directly in front of the door.
Okay. So obviously he was in front of the door, he was sitting there, and you said he had a gun, right?
Yes.
And you testified on direct. You weren't positive what kind of gun it was, but you were positive that he pointed the gun at you, correct?
Yes.
And you're absolutely sure of that as you sit here today, that he pointed that gun at you, aren't you?
Yes.
And you indicated you didn't know what was going to happen. And you said that you thought because he was pointing this gun at you that you were going to get shot. That was your testimony, right?
That's one thing that could have happened.
Okay, but that's what you testified to, correct?
Mm-hmm.
You said,
yes.
I didn't know what was going to happen, but I thought I was going to get shot. That's what you said here a few moments ago, right?
Yes.
Mr. Jackson asked you the question, ma'am, of whether or not you had by law enforcement.
Yes.
You spoke with Investigator Tomlin, is that right?
Yes.
And as I understand it, Investigator Tomlin was accompanied also by Investigator Paul Fournier. Is that right?
I believe so.
And this conversation took place in about January, sometime in January of 04, specifically January 5th of 04. Is that right?
I don't know the exact date.
All right. And you were with Mr. Resnick, Mr. Bernie Resnick. Let me, hold on, sorry. I just want to spell it for our reporter. It's Bernie Resnick.
Yes.
And Mr. Resnick was serving in the capacity as your lawyer at that time, right?
Yes, he is my lawyer.
Okay. Now you remember Mr. Fournier and Mr. Tomlin told you that they wanted to speak to you about what you knew about Phil Spector and in particular any incidents that occurred at the Carlisle Hotel, right?
Yes.
And they told you that they wanted you to be truthful with them, right?
Yes.
That's all they wanted you to do, just wanted you to be truthful, correct?
Correct.
And they wanted you to tell the whole story, the complete story, not leave anything out, right?
Correct.
And they told you in doing that, that they wanted you to be forthright with them. That's correct, isn't it?
Of course.
And you spoke with them, didn't you?
Yes, I did.
And you spoke with them for a period of time. It was, what, several hours, wasn't it?
I don't recall how long.
Where were you when you spoke with them? You were in Philadelphia, correct?
in my lawyer's office,
I'm sorry,
in my lawyer's office
in
in
Philadelphia,
Philadelphia.
Pennsylvania.
Mhm.
They came out to you, right?
Yes,
And you knew they were coming. This had been prearranged, right?
yes,
And you knew it was to talk to you about Phil Spector and the Carlisle incident.
yes,
And you also knew before they came out that there was a possibility this was going to be tape recorded and transcribed, correct?
yes,
And in fact, when you went through the interview with them, it was tape recorded, wasn't it?
yes.
And it was transcribed, wasn't it?
I never saw the transcription.
Okay. But you know that one exists.
I don't even know it exists.
Do you recall, you're on reference for the government. Go to. Do you recall the following questions and the questions by Officer Fournier, Investigator Fournier, and you providing the following answers to those questions, okay? And I'm going to read it to you. And for the record, Your Honor, this is page 31 of the transcript of January 5th of '04. Question by Mr. Fournier. Okay, this particular evening, he doesn't want you to leave. He's sitting in front of your door at the hotel. He took this gun out. Now, where is he pointing the gun? Jennings. He did. He had it like he's sitting there with Fournier. So cross-armed? Jennings, yeah. Fournier, in front of the door and he has it in his hand? Jennings, yeah. Fournier, okay. And he's not pointing it in any particular direction? Jennings, no. Fournier, what is he saying to you? Jennings, that, I had to leave my bags there. I was going anywhere. Ms. Jennings, you certainly recall providing those answers to those questions when you were interviewed in January of '04 in the presence of your lawyer, don't you? Yes or no?
No, I don't recall
May I
exactly.
approach, Your Honor?
Well, I don't know that showing her is going to refresh your recollection.
If I showed you the transcript, and please accept that this is a correct transcript of the taped interview. If I showed it to you with the questions and answers that I just read, might it refresh your memory as to the answers you provided to the questions by Detective Fournier at that time?
I believe what's written, I believe that's the transcript.
I understand that, but we have certain procedures we have to go through here. I'm asking you this. I know you're not quarreling with the accuracy of the transcript. What I'm asking you is if I gave you this transcript for you to...
Aren't you supposed to give it to her first instead of reading it out in court? Isn't that the right way to do it? And you just read it to her. If she doesn't remember it when you read it to her, she's not going to remember it when she looks at it. What the heck? She doesn't remember. She doesn't remember. She doesn't remember.
Read would refresh your memory as to the answers that you provided to those officers. If it would, it would. If it won't, it won't.
It possibly could. Everything's been such a long period of time
May I
between all
approach?
of this.
You may approach.
Thank you. Let me explain what I'm going to do. I'm going to hand you the transcript, okay? You just to read it to yourself. I'll point to the area, okay? You're not to read it out loud. When you finish reading it, you let me know, and then I'll have some questions for you, okay? And for the record, you're on page 31, starting at line 11, and you'll conclude your reading up here at line 2, okay? You just read it to yourself, please. Thank you. Have you completed reading it?
Yes.
Okay, thank you very much. Having now read the transcript of your taped interview in January of '04, Ms. Jennings, does that refresh your memory that you provided those answers to those questions?
Those are the answers I provided at that time.
Thank you very much. Council, turning to page 69, please, lines 4 through 12. I'm going to read you further in the transcript, okay? And I'll ask you whether or not you recall providing the following answers to the following questions in the same interview in Mr. Resnick's office in Philadelphia, Pennsylvania, in 2004, okay? Excuse me, this is by Mr. Tomlin, his partner, starting at line 4. Tomlin, okay, so now he's in front of the door. He's got the gun. He's now waving it. Is he waving it? Jennings, no. Tomlin, he's just got it. Jennings, he's sitting there. Tomlin, he's sitting there. Jennings, yeah. Tomlin, with it like cross in his arms. Jennings, yeah. Tomlin, and you're not going anywhere. Jennings, right. You recall providing those answers to those questions later on in that same interview?
Yes.
Your Honor, with one question, if Mr. Rosen would please quote the internal quotations, and I think it gives it context. It didn't sound like he did.
All right, that's fine.
It's just line 14.
Line 14, Tomlin, and quote, you're not going anywhere, close quote, question mark.
All right.
Okay.
So in this interview, which was, as I understand it, your very first interview, face-to-face with law enforcement in regards to this incident, you did not tell them that Philip Spector pointed the gun at you. Isn't that correct? Isn't that what that says? Just yes or no, ma'am?
That's what the transcript says.
Okay. Now, at the point that the gun comes out, your fear level really went up, didn't it?
Yes.
You're really concerned for your life, aren't you? You're concerned for your safety, correct?
That's why I called 911.
Correct. And I think you indicated you got 911 and you spoke with a very nice female voice who assisted you. Is that correct?
Correct.
During that time, you were scared, correct?
Yes.
You were extremely fearful, correct?
Yes.
This was way beyond being threatened. You were in fear of your life, correct? That's
Yes.
a fair statement. Okay. You were shocked by this question.
Yes.
And in addition to being shocked by this, as I understand it, it would be an understatement, a total understatement to say that this bothered you, correct? It was much more than that, right?
Yes.
Court's indulgence for a moment, please.
All right.
Sorry. Orient Mr. Jackson.
So
Ms. Jennings, again,
an understatement that it upset her. Does that mean that she overreacted? Is that a nice way of saying that she overreacted? What the heck was that?
I'm going to read to you from the transcript of the tape recording of the interview with you and Detectives Fournier and Tomlin in January of 2004 at your lawyer's office in Philadelphia. Please pay attention if you would, ma'am, and let me ask you whether or not you provided the following answers to the following questions. Starting at line 3, Fournier. Okay, well, we'll go back. So this particular incident, now again, you have to tell us. I mean, I don't want to put words in your mouth, but I mean, did you look at it like you continued to date him at that time, correct? Jennings? Mm-hmm. Fournier. So I mean, how did you didn't view that incident that you felt threatened? Jennings? No, not exactly. I mean, at the time, I was into shooting a lot. I was around these people a lot. So, Resnick, are you shooting guns or are you shooting photographs? Jennings, photographs. Thanks for clarifying that. Resnick, you're welcome. Jennings, Resnick, they don't pay me the big money for nothing. Fournier, I'd figured that as much, but yeah, good clarification. Jennings, this was just kind of, I guess I would say, his normal lifestyle. So like being around guns and alcohol and everything, Fournier, okay. Jennings, so. Fournier, the shock factor wasn't there for you. Jennings, right. Fournier, because you had been around people that acted. Jennings, yeah. And for one thing, my grandfather, I grew up with guns with. My grandfather had one in every cupboard in the house. Fournier, oh really? Jennings, behind every door. Fournier, okay. Jennings, so it didn't, like the whole thing just didn't. Fournier did. Jennings, bother me. Fournier, did you ever talk with Phil about this incident after it occurred? Jennings, no. Miss Jennings, do you remember providing those answers to those questions at your tape interview with those two detectives on January 5th, 2004 at your lawyer's office in Philadelphia?
I don't remember the exact conversation, but that's obviously what it was.
Miss Jennings, I prefaced my questioning in this area with the question to you that the officers told you to tell the truth, and you said yes, correct?
Correct.
And they told you to tell the truth before you started the interview, correct?
Correct.
And they told you to be truthful throughout the entire interview, correct?
Correct.
Miss Jennings, you have never, ever seen Phil Spector take a gun out himself and display it in a threatening manner to anyone else. Isn't that correct?
Take it out now.
You've never seen him pull a gun on anybody else, have you?
Not pulling out.
As a matter of fact, I want to direct your attention to another area of questioning by Investigator Fournier on this same subject regarding your fear at the Carlisle Hotel. Moment, please. Do you remember providing the following answers to the following questions? Jennings, I don't know exactly. To say I never thought, I never, parens, someone sneezes, close parens. Tomlin, bless you. Jennings, what? I never really thought that he was there going to use it to kill me. Fournier, okay. Jennings, I never thought he would purposely use it to kill anyone. It was just, he had a lot of things with the lifts in his shoes, from his hair pieces to, the gun being, part of it. That was just part of it. I guess trying to make himself seem like a bigger man. Miss Jennings, do you recall providing those answers to Mr. Tomlin's questions, to Investigator Tomlin's questions in your lawyer's office in January of 2004?
I don't recall, but that is along the lines of what I think.
Now, Coach, let me ask, if I showed it to you, might it refresh your memory?
Well, like I said, I'm assuming it is on there.
It is on here, but might refresh your memory.
Well, there's no need to approach. If she doesn't disagree, are you agreeing that if it appears in the transcript that that's what you said to
Yes.
those officers?
Very, thank you. You told me and you told Mr. Jackson there was no question you felt threatened and you were fearful, correct?
That's why I called 911.
Once again, ma'am, I would like to take the opportunity to read you from the transcript. Okay? I just want to give Mr. Jackson a moment to get it. Okay, great. Would you please listen to the following questions and answers? Question, Fournier. Okay, well, we'll now go back. So this particular incident, now again, you have to tell us. I mean, I don't want to put words in your mouth, but I mean, did you look at it like it? I mean, you continue to date him at this time, correct? Mm-hmm. Fournier. So I mean, how did you didn't view that incident that you felt threatened? Jennings, no, not exactly. And then, I think we've done that, yes.
Yeah, Mr. Rosen,
I'm sorry, we have already done it, that's correct. Let's talk for a moment about the fact that the police arrive at your room, okay? When they arrived at your room, as I understand it, they had the general manager with them,
I believe so.
and there were a number of New York Police Department officers, correct?
Yes.
It wasn't just one.
No.
And as I understand it, when they came into your room, you spoke to them, correct?
Yes.
How long, Ms. Jennings, did you speak to them for? 5 minutes, 10 minutes, 15 minutes?
I couldn't tell you.
Long enough to tell them what had happened before Mr. Spector left the room, correct?
Yes.
And you told him that Mr. Spector had a weapon, correct?
Yes.
You told him he had a handgun, correct?
Yes.
Do you know, as you sit there today, whether or not they went down to Mr. Spector and arrested him for having a handgun?
objection calls for stipulation.
Unless you personally know that, are you able to?
No. No idea.
The objection is?
Let me ask you this. Are you familiar with something called the Sullivan Act in New York?
Objection relevant.
Sustained.
I'm just asking if she's familiar with
It's
it.
irrelevant. Sustained.
Now, as I understand it, you indicated that after the incident at the hotel, you did not press charges, correct?
Correct.
You didn't sue Mr. Spector, correct?
Correct.
You never went to criminal courts in New York and testified, right?
No.
And all I think you said you wanted to do was to just get out of there, referring to the hotel room, right?
Yes.
You then testified that you were invited to the same event next year by Phil Spector, is that right?
Yes.
And you agreed that you would go as long as he provided that you had your own room.
It was
Correct?
basically under the condition I wouldn't be seeing him.
That you have your own room, correct?
I'd have my own room.
I just asked you whether or not one of the conditions were that you'd have your own room.
Yes.
And he agreed to that, correct?
He
that right?
suggested it,
Okay. And he paid for that, right?
I'm assuming.
And he paid for your fare up and back to and from New York, correct?
Yes.
Also, as I understand it, he was very gracious with you. He sent you wine, he gave you money at times, he provided you limousine services, took you to dinners, many, many nice things, right?
Yes.
And it was on an ongoing basis, correct?
Yes.
Now, you testified that after that time, and that would have been in 95, you no longer had any romantic relationship with him. Is that correct? That's what you testified to. You said that this morning, right? When Mr. Jackson was asking you questions. After this, I no longer had a romantic relationship with Phil, correct?
I'm not sure of all the dates.
No, that's not what I asked you.
Your Honor,
What I-
witness could please
Well,
fill out
I
the
think it's
explainer.
been answered, and I'm going to allow the question. You may proceed.
Thank you. My question was, did you hear witness and answer Mr. Jackson's question, tell him that after that 2005 event, I'm sorry, excuse me. Sorry, I misspoke, 1995 event, you and Mr. Spector no longer had a romantic relationship. That's what you testified to, correct?
Correct.
Again, I want to reference you to your first interview with Mr. Tomlin and with Mr. Fournier, the two case agents, the two investigators in this case. And I want to read to you from a portion of that investigation from the transcript and tell me whether or not you recall providing the following answers to the following questions. Tomlin, so how long would you say you were romantically involved with him, if you will? Jennings, Tomlin. From 94 to 96, what? Jennings. Yeah, from the time you know, first time I stayed with the Carlisle till you know the last time. Did you provide the answer yeah to the question from 94 to 96? If you want to, I'll show it to you.
Obviously, that's what I said.
Okay, that's all I'm asking you. Let's talk about the sale of your photos. I think you indicated there came a time where you met with a gentleman from the National Enquirer. Is that correct?
A writer.
Okay, a writer from the National Enquirer. Somebody who writes stories for the National Enquirer, correct?
Yes.
And you met with him because he wanted to talk to you about what you knew about Mr. Spector and for you to provide photos. But actually, you were under the impression that you were just going to provide photos, correct?
Basically.
And you testified in the grand jury in this case, didn't you?
Yes.
And you testified before the grand jury on September 8th of 2004, isn't that right? And I'll tell you, I'm not trying to pry the ball. I've got your transcript, okay?
Right.
All right. And you were asked that question by Mr. Doug Sortino, who was the deputy district attorney then assigned to the case before Mr. Jackson came on board, correct?
Correct.
And Mr. Sortino asked you about that, didn't he? He asked you about the subject matter regarding the sale of your photos to the National Enquirer, correct?
Correct.
And I think in discussing that with Mr. Sortino, you indicated to him that you did not believe that you were going to be the focus or subject of an article, just that your photos would be bought and used for an article about Phil Spector, correct? That's what you testified to before the grand jury, am I correct?
Correct.
You signed a contract with the National Enquirer, didn't you?
Yes.
And in signing that contract, you affixed your own signature and dated it to the end of that 3-page contract, didn't you?
Yes.
And of course, you read it before you signed it, didn't you?
Probably.
Okay.
It was before I got my lawyer involved, because it was at the very
I
beginning.
didn't ask you about your lawyer. I asked you whether or not you signed this contract.
I
And you
signed
said
it.
yes. And you said you read it before you signed it,
I
correct?
might not have read it completely.
You got paid $1,000, correct? Not $1,200.
Whatever it says on the contract then.
You testified this morning that you got paid $1,200.
I thought it was around 1,200.
Okay. Your Honor, might we have the contract on the board?
All right. Do you want this marked as an exhibit?
Yes, we do, Your Honor. Please.
Your next is
Defendants.
I.
Please.
All right.
Can we make that J?
Sure.
I will be the transcript that goes with H.
Okay.
No problem.
Thank you.
So we're on J. Mark the defendant's J, Your Honor, please.
All right.
Thank you. Ms. Jennings, can you see what's been projected up on the screen?
Yes.
Okay. Can you read it okay? Can you read it okay? Do we need it?
A little bit.
Jen, could you help us a little bit, make it a little bit larger so Ms. Jennings has an opportunity to read that? Okay. First of all, let's go to the top. It says Enquirer, National Enquirer, correct? Correct?
Yes.
And in the middle of the page, Jen, can you drop the overlay down? Thank you. It says the word agreement, correct? Yes?
Yes.
All right. Could you blow up, please, number 1? Do you see that?
Yes.
Okay, that reads 1. You agreed to provide the Enquirer with a full, complete, and accurate interview regarding your personal knowledge of who?
Phil Spector.
This gentleman seated right here, correct?
Yes.
Okay. There's a word photo or is there?
No.
When you read that, what did you think it meant when it said you agree to provide full, complete, and accurate? That if they asked you questions about Phil Spector, you were going to tell them whatever it was you couldn't answer the question. Volunteer the information, correct? What that meant to you?
No, it isn't.
Look at that language. Does that language indicate to you that what it means is you're going to be providing
providing photographs only? It doesn't. Not, does it?
I did not see this until,
That wasn't my question. My question is simply this. Take a look at the language of paragraph 1. Does that language suggest to you that the only thing you're going to be doing is providing photographs? The answer is no, isn't it?
no.
Let's take a look, if we could please, at number 3. Could you blow that up? In 3, it says, you agree to provide the inquirer with any pertinent documents and photographs relating to the information provided in interviews with you. You see the last 4 words, in interviews with you?
Yes, I can see the words.
At that time, did you not take the word interview to mean question and answer? Obtain information from you? You did, didn't you? Isn't that what it meant to you?
The writer and I had, it was an informal conversation. It wasn't an interview, in my opinion.
I understand. What did the word interview mean to you when you put your John Hancock on this agreement? What did it mean to you?
Obviously, I didn't read it thoroughly.
Let's take a look at 6. No, excuse me. Let's go to 7. Please, could you blow that up, Jen, if you would? Thank you. Would you take a look at 7? Do you see the words in 7? Interview, information, documents, photographs? You see that?
Mm-hmm. Yes.
What did that mean to you when you saw the words interview, information, documents?
It meant what the writer and I had talked about and the photos that I had shown him.
Okay, let's take a look at number 9. This is just to refresh your memory. I realize you testified here today that it was $1,200. Now that you see that, you realize it's incorrect. It is wrong. It's not $1,200. You only got $1,000. Correct?
I can see that.
Do you agree with that? It's right there in the agreement, correct?
Yes.
All right. And now let's take a look at paragraph 12. Would you please take a look at that? It reads, 12, you agree that you will provide the inquirer with an exclusive interview. Exclusive interview. You agree that for a period of 3 months, you will not provide any other reporter or news media the same or similar interview, information, documents, or photographs contemplated in this agreement without the inquirer's written permission. See that?
Yes.
That's in your agreement that you signed with them, correct?
Yes.
And finally, let's take a look at paragraph 14 on the next page, please. Jan, if you would. Could you kindly assist us and blow that out? Thank you so much. 14. You agree and acknowledge that nothing in this agreement bars the inquirer from publishing any article about Phil Spector or others that relies on information and documents other than that provided by you to this agreement. What is the only proper name you see in that paragraph? Phil Spector, correct?
Yes.
And the information and documents that you are to provide is in reference to who? In reference to him, Phil Spector, correct?
Yes.
No one else. And finally, if you go up the bottom part of that, please, from where it's agreed to this date all the way to the bottom, please. Thank you, Jim. No, above that, please. Down. No, could you go down, please? That's fine, thanks. Right. Okay. Would you look to the right, please? Well, first look at the top. What is the date on that?
February 5th, 2003.
Okay. And take a look to the right. You see a name written in block letters, Stephanie Jennings.
Mm-hmm.
It's your handwriting, isn't it?
Yes.
And below that, in cursive, there's a signature, isn't it?
Yes.
Whose signature is it?
Mine.
The one you put on the agreement, correct?
Mm-hmm. Yes.
And when did you make this agreement with them? As I recall, it was on February 5th, 2003.
Obviously.
That happens to be a date before you spoke with the detectives in this case, isn't that true?
Yes.
So you made this agreement and you got paid for your interview, your information, your documents, and your photographs, $1,000 by the National Enquirer before you ever spoke to anybody in law enforcement, correct?
Correct.
You have a point. There was some personal information the witness asked. There was identifying
We'll redact
information.
I'm sorry.
Well,
I
it'll
certainly-
be redacted.
Yes, we'll read
Okay,
it.
thank
We'll
you.
block that out. Okay,
All right.
thank you for bringing that to our attention. I apologize. Just a couple of other areas that I want to address. When was the last time the last time you had contact with Mr. Spector was in the year 2001, right around the time of the Rock and Roll Hall of Fame. Isn't that correct? The induction ceremonies?
I don't know.
Okay. Would you quarrel with me if I told you that you had contacted him at that time and or he had contacted you to invite you to the induction ceremonies in 2001? You wouldn't quarrel with that, would you? You just
No.
don't remember.
Correct.
Regarding this alleged incident that you said occurred at Carla, as I understand your testimony, both on direct and cross, you never touched the gun that correct, that morning?
No,
He never asked you to touch it, correct?
not that morning, no.
He never put the gun in your hand, did he?
No,
He never asked you to take the gun and place it inside your mouth, did he?
no,
And he never did that to you, did he?
no.
You did not inspect the gun that morning, did you?
No, I did not.
You don't even know if it was loaded, do you? Not what you assume, not what you assume. You don't know that it was loaded, do you?
I don't know if it was or wasn't loaded.
It was never discharged, correct?
No,
And you never looked at it closely to inspect, in fact, if there were bullets in the chamber.
no.
May I consult with my colleagues for a moment
You may.
before I conclude? That's why it's helpful to have a great defense team. You can't think of everything. As I understand it, Mr. Spector came to your room twice, according to your story at Carlisle, right? He came into the room twice.
Yes,
Okay. First time is when we had the bathtub incident when you shove him in the tub and he falls back into the tub, correct? And he leaves.
mm-hmm. Yes,
Yes. And the second incident is when he returns allegedly with a weapon, correct?
yes,
Now, as I understood it, he returned very quickly. It was just a matter of moments after you shoved him in the bathtub, right?
I don't know how long it was.
Well, it was only a matter of minutes, wasn't it, at the most?
It wasn't very long.
And there was again a knock at the door, right? And it was Mr. Spector, correct?
There was no answer to the earlier question. There was a knock at the door the second time? Yes or no?
No, there was another knock at the door the second time.
Okay. You opened the door for him, is that correct?
Not the second time.
How did he get into the room?
I don't know.
You have no information that he had your key, right?
No, I don't know if he had my key or not.
Okay. You don't recall going to the door and opening it so that he could enter?
Not the second time, no. I was still in the bathroom packing my things.
Okay. Here, I'm going to just need one moment. All right. If I may, Mr. Cutler reminded me of something and I just need to locate it.
All right.
Thank you for your patience, Your Honor.
No problem.
Thank you, Ms. Jennings. No further questions.
All right, redirect.
Do you know when Phil Spector walked out of the hotel room after the incident in the bathroom, whether he left the hotel door ajar?
I'm not sure.
You didn't open it for him.
No, I did not.
So it's most reasonable in your mind that he just walked out the door, left it ajar, walked down the hallway, got his gun, and came back, correct?
The objection is sustained. The answer is stricken. The jury is admonished.
Now, you were asked about a contract that you signed, in your words, for the use of your photographs and some information that you may provide for an article about Philip Spector, correct?
Correct.
Okay, and in the contract that Mr. Rosen showed you on the board, in several different places, in a blank that was left blank, i.e. the subject matter of the contract, it was handwritten in, it was about Philip Spector, correct?
Correct.
The interview was not about Stephanie Jennings, was it?
No.
Did you agree to be interviewed about Stephanie Jennings?
No.
Did you agree to be interviewed or the use of your photos for Philip Spector?
Yes.
Were you shocked when you read the article and it was more about you and your incident with Philip Spector rather than the 2003 incident with Lana Clarkson?
Yes. I'm going to allow the question. You may answer.
Yes.
All right. Now, you also saw that contract appeared to be what folks in the entertainment business may call a standard contract, correct?
Correct.
All right. In other words, did you sit with a lawyer and sit there and type out that contract, or was that brought to you for your signature, or Mr. Rosen put it, your John Hancock would be more appropriate. Was that provided to you, or did you sit there and hash out the wording of the contract with your lawyer?
It was brought to me to sign, and I should have hashed it out with my lawyer.
Okay. Hindsight's 20/20, right?
Yes.
In every place that Mr. Rosen mentioned the word interviews, doesn't it also say interviews, information, documents, and or photographs in that contract?
Yes.
All right. Was it your information and belief when you signed that contract that you were providing the use of your photographs and all publication of those photographs that you provided for this National Enquirer article?
Yes, I provided them with several photos to use.
Okay, and you had no problem with that?
No.
And in fact, if the writer took certain information that you gave him during an informal interview, that was fine too, correct?
Correct.
Fine. You didn't realize the extent to which that article was going to talk about you as opposed to Philip Spector, where it said Philip Spector over and over in the contract. Is that right?
Correct.
All right. Mr. Rosen, quoted some language from an interview that you did with Detectives Fournier and Tomlin. And counsel, this is on Bates 3625, or in your page, it'd be page 38. Sure.
Okay.
Ready, counsel? Okay. May I, Your Honor?
Yes, but by the way, for the jury, when you hear the term Bates, if you're not familiar with it, it's a stamp with numbers on it that so people can keep track of discovery that's turned over. It's called a Bates stamp. And that's why that reference means that they're giving that number so the other side can find it. That's what it means. All right, you may proceed.
Thank you, Your Honor. Do you remember Ms. Jennings stating, and this was quoted in brief by Mr. Rosen, but I want to reiterate, do you remember stating at line 10, Ms. Jennings speaking, quote, I mean, I never thought he would purposely use it to kill anyone, referring to the gun. Do you remember stating that?
Correct.
Is that in fact your belief?
Yes.
Was it your belief back in January of 1995 when Philip Spector pulled this gun on you?
I didn't believe he would purposely use it to kill me,
That's my
but it
question.
could happen.
Okay. My next question is, are you aware that if guns are pulled, sometimes people get killed?
Correct.
Was that?
I'm going to check.
I want to sustain the objection.
Motion to strike, please.
Excuse me. It's argumentative. The motion to strike is granted. The jury is admonished to disregard.
Although, I'm sorry, Mr. Rosen.
That's okay.
All right, you may proceed.
Although you didn't believe at the time that Mr. Spector might use the gun to purposely kill you, did you have fear in your mind that the gun could kill you, whether he purposely intended it or not?
Yes.
Yeah, the objection is overruled. The answer will stand.
Is that why you called 911?
Yes,
And Mr. Rosen also asked you a couple of questions about the difference between your phraseology, pointing the gun at you and waving it around. All right, what is your best recollection, Ms. Jennings, as you sit here today about how Mr. Spector was using that gun? Was he using the gun in a threatening manner, or was it more like, oh, here's my gun and I'm polishing it?
Well, no, he gave two alternatives which are diverse and I believe are appropriate. The objection is overruled. You may answer.
it's a threatening manner.
All right, did you feel threatened?
Yes, I did.
At times, as Mr. Spector was waving the gun around or displaying the gun or whatever word you want to use, was that gun pointed in your direction?
Yes, it was.
Did you believe, as you sat in that room or stood in that room, did you believe that Mr. Spector was utilizing that weapon as a threat against you and your person?
Objection, call for conclusion, no foundation.
Overruled. It calls for her state of mind as to how she felt. You
No,
may
the
answer.
question, Your Honor, if I may, I don't want to argue with the court, but the question is, I heard, maybe I'm mistaken, but as I heard the question is, what was in Mr. Spector's mind?
It's how she felt about what it was being used for. So it's sort of a combination. I'll allow her to offer her opinion. You may answer the question.
Yes, I felt I was being threatened with it.
And again, is that why you called 911?
Yes,
Mr. Rosen also asked you about Mr. Spector's many nice qualities. And I think he mentioned the fact that Mr. Spector did many nice things like, I don't know, send you wine or cards or letters or take you out to dinner or send limos for you and things like that.
yes,
Okay. And you agreed that, yes, he did, in fact, over the course of your relationship, have those qualities, correct?
You know, you can give me wine, flowers, candy, take me out to dinner. You wave a gun at me, though, none of that matters. I don't care who you are. I'm sorry.
Right?
yes,
Did he also have an ability to snap and change his mood immediately?
yes,
Did you ever see that personally?
yes,
Was this incident with the gun one example of that?
yes,
Was the incident where he left threatening messages on your machine another example of that?
yes,
So were there, in fact, in your mind, two Philip Spectors?
yes,
Did you see the alternative Philip Spector come out that night at the Carlisle Hotel after Philip Spector had been drinking heavily?
yes,
Did you see that alternative Philip Spector come out after you said, I'm going to leave?
yes,
Did you see that alternative Philip Spector come out when he pulled the gun on you in the Carlisle Hotel?
yes,
Was that someone that you were not used to? In other words, was that a different person than you were used to, the nice Philip Spector that Mr. Rosen asked you about?
yes,
May I have just a moment, Your Honor?
You may.
Mr. Rosen also asked you specifically, have you ever seen Mr. Spector, other than the occasion when he did it to you, Ms. Jennings, had you ever seen or were you aware of Mr. Spector ever displaying a gun in any other circumstance in a threatening manner on anyone else? Do you remember him asking you that question?
yes,
And you indicated that you had not personally seen that.
correct.
Are you aware of other incidents when Philip Spector has pulled guns on other individuals in threatening manners?
Well, objection, we need a foundation.
I agree. There has to be a foundation and a showing of personal knowledge, if you wish to.
May I have just a moment, Your Honor?
You may.
Your Honor, I think that's all I have for Ms. Jennings. Thank you.
Thank you. Recross.
Recross, please, Your Honor.
Yes.
Ms. Jennings, you just told Mr. Jackson once again, for the second time, you were frightened, you were scared, this bothered you terribly, it was a horrible thing for you, correct? You just told us that here, sitting in this courtroom.
That misstates the
I
testimony.
don't believe those are the words she used, so the objection to the form of the question is sustained.
When I asked you on cross-examination if you felt frightened and scared, you said yes, correct?
Yes,
You said you felt threatened, correct?
yes,
You said to me, you told me on cross-examination that you were terribly bothered by this incident, correct?
yes, that's why I called
No, I
911.
just yes or no.
She said yes, and that's why I will allow the entire answer to come.
Thank you. When I refreshed your memory, or tried to, by reading the transcript of the interview approximately 3 years ago with the two case agents, the two investigators, I pointed out to you that you said exactly the opposite. Were you lying then or are you lying now?
The objection is sustained on.
Let me ask you
No,
this.
just a second. The objection is sustained on several grounds. It's an appropriate question. You may proceed.
Thank you. Let me ask you this. You understand you have an obligation to tell the truth as a sworn witness?
Objection, this is argumentative, Your Honor.
I'll allow that. You may answer that.
And you can answer.
Yes,
You also understood you had an obligation to tell the police the truth, correct?
yes,
You recall telling Officer Fournier that you did not view that incident that you just described for Mr. Jackson in a threatening manner, and you said, no, not exactly. You remember saying that?
not exactly.
You remember saying, no, not exactly.
No, not exactly.
Okay? No, not exactly that you don't remember saying that, or no, not exactly that's your answer?
I guess
You want me
it's
to
a
bring
little
the
of both.
All right, you want me to bring the transcript up to you?
Yes, please.
Okay.
All right, you may approach.
When Officer Fournier,
Page, counsel.
3635 for you, page
Thank you.
Hold on, let me get to it. Okay.
Yes, thank you.
Did Officer Fournier ask you the following question? So I mean, how did you didn't view that incident that you felt threatened? Did he ask you that question? Is that the question he asked you?
That's the question he asked me.
Tell the jury what you said.
I said, no, not exactly.
Would you look further down? You've answered the question, further down. Did you tell Officer Fournier, the case agent in this case, this was just kind of his normal lifestyle? So like being around guns and alcohol and everything, the shock factor wasn't there for you? Right. Did you answer those questions in that way? Just yes or no, ma'am?
Yes,
Okay. Did you also answer them in the following way to the following questions? I mean, I grew up with guns. My grandfather had one in every cupboard in the house. Fournier, oh really? Jennings, behind every door. Fournier, okay. Jennings. So it didn't, like the whole gun thing just didn't. Fournier did. Jennings bothered me. Those are your words that you spoke out of your mouth to that officer at that time, yes or no?
yes, but that's
No,
out of
just-
context. Well,
It's in the transcript, man.
it's in the transcript, but the context is, that's not what we were talking about.
That's not what you meant?
We were talking about,
No, is that not what you meant?
No, excuse me. She's explaining, you've brought up what you believe to be a difference and what may be a difference. She's trying to explain why there might or might not be. You may explain.
we were talking about, he had guns around when I was around.
Okay.
And that didn't bother me that he always had guns around. I didn't think he would be pulling them on me.
What I asked you was this. Did you make these statements to these officers at that time when you weren't in a court of law in front of a jury? You did, didn't
Those
you?
are the statements I made, and
Thank you.
they're not
Thank
in
you. Answer the
context.
question.
Now, ma'am, excuse me, Mr. Rosen, she has not answered the question. I just tried to explain to counsel, and
I'm
if
sorry.
you want me to interrupt, I will.
No, I'm sorry.
But yes or no does not always answer the question. But if it's appropriate for the witness to explain an answer, they may. You may explain your answer.
The context that they were talking about then is him having guns around and his actions in general. There was alcohol around, there was guns around in general. We weren't talking the specific Carlisle incident.
Well, when he asked you about feeling threatened at that incident, he used the word incident, referring to the Carlisle incident. That's what you were talking about in the prior pages, isn't it? You want to sit and read the transcript? I'm happy to present it to you to do that. Isn't that when he uses the word incident, that's what he's referring to, correct?
If you flip the next couple pages that you showed me, it said that he had the alcohol and guns around. That was just part of him.
Ms. Jennings, when the question was asked of you, you didn't view that incident that you felt threatened. No, not exactly. You understood that was referencing the Carlisle incident. That's what you were in the middle of discussing with Detective Fournier at that time, correct?
I would have to read the entire transcript because
Well, we
it
have a
seems
one-
to be out of context.
Okay, let me ask a different subject. This agreement that Mr. Jackson asked you about, correct? You signed it, right? Is that correct? The agreement with the National Enquirer?
Yes,
Nobody forced you to sign that agreement when you put your pen to paper, did they?
no,
Nobody demanded that you sign that, did they?
no,
Nobody said, hey, wait a minute.
You can take a moment if you want and read this over as long as it's necessary, or you can get legal counsel on this. Nobody did that for you, did they?
No,
And nobody prevented you from doing that, correct?
no, I didn't know at the time. I should have.
I didn't ask you what you should have. Isn't it true that if you wanted to, all you had to do was ask this gentleman who worked for the National Enquirer that you needed a few moments to maybe call your lawyer on the phone and read it to him or meet with him before you signed it, and you didn't do it, did you?
No, I didn't do it.
Thank you. Nothing further.
Thank you. Leave the record.
All right?
Subject to recall, you're excused. Thank you for being here. You may step down. We will be in recess until 1:30. Keep in mind the court's admonition. Thank you. All right?
Okay, guys, that's it for today. I don't like that guy because I get what she's saying. He had guns around him all the time. She wasn't afraid of the guns. She wasn't afraid of the fact that he had alcohol and guns around him all the time. It's when he was drunk and had the guns out because he didn't want her to leave. She wouldn't have called 911 if she didn't feel threatened. I mean, and even if she thought, oh, he's not going to point it at me and pull the trigger, he's drunk and he's waving it around, anything could have happened. I mean, come on. What an idiot. What an idiot. He has a pattern. Is this the third girl now? Yeah, this is the third one. He has a pattern. They say they want to leave or don't want to do what he wants, and out comes the gun. All right, guys, I will see you tomorrow. Hopefully I will have that special stream ready tomorrow. I hope it's going to be a fun one. So we'll do Phil again in the morning, and I hopefully will have the other one ready for tomorrow afternoon sometime. Have a nice weekend if I don't see you. And thank you guys for coming out again. I love you guys. Bye.